Hey everybody. We're going to be looking at oral arguments at SCOTUS that took place yesterday on March 31st of 2026 in the case of Pitchford v. Cain. It's being called a Batson Challenge racial discrimination case, but there's a layer to it where I think the question is a little bit more complicated than that. With Pitchford's appeal to the Mississippi Supreme Court, well, actually it was a state that appealed a Fifth Circuit decision, a different decision from a lower court. Mississippi Supreme Court ended up saying, you know what, Pitchford, sorry, but your counsel actually failed to sufficiently argue for you and for these challenges, these Batson challenges, against the prosecutor's decision to try to strike jurors. You alleged at trial, you objected, you said that, hey, we think these strikes are, there's an intent to discriminate in why you're trying to strike these jurors. So they objected at trial. The process for that, when there's a Batson challenge, the prosecutor gets to state their reason, give an explanation. Hey, normally we don't need to explain a peremptory strike, but since there's been a Batson challenge, we have to explain, we just think there's something off about this person's demeanor, or we don't like that their history includes that they work as a postal worker. And they give their reasons. And then the judge makes a finding on whether or not that involves some type of discriminatory pretext and either sustains or objects the ruling from the opposing counsel. In Pitchford's case, and we're going to go through some background here to get us oriented, the real issue is not just whether or not these strikes should be viewed as having some type of discriminatory pretext or not. It's whether or not, after the trial court said, okay, we hear your explanation, prosecutor, and we don't think that there was an intent to discriminate behind your use of your peremptory strikes, so we're going to overrule the defense's Batson challenge objection. The Mississippi Supreme Court said, you know what? Sorry, you didn't fight hard enough. You should have continued to fight. And because you didn't fight at the trial court level, and trial went on and you got convicted, you waived your argument to challenge this striking of these different jurors. So it's kind of a waiver argument couched within the context of Batson challenge issues. So let's get some background, and we're going to watch the SCOTUS arguments that took place yesterday. Again, this case, it's Pitchford v. Cain. Oral arguments were yesterday. This case stems back quite a ways. And if you want these resources here, if you want to do the deep dive on the background, this is linked in the description as a Gamma document. But you can go and listen to the September 4th, 2024 arguments in front of the Fifth Circuit Court. And then also, I linked a case. It's a different case here. You'll see Flowers v. Mississippi. This is a different argument in front of SCOTUS from 2019, March of 2019. This case was overturned. This was a case where Curtis Flowers, might be a familiar name to some, argued that jurors that were stricken at his trial, they were stricken improperly. It was a Batson issue. And SCOTUS ended up agreeing. SCOTUS ended up agreeing that, you know what? Curtis Flowers was deprived of a fair trial. And the issue was a clear Batson issue, where the prosecutor at trial was making use of his peremptory strikes to strike black jurors with the intent to discriminate. The reason I link this here is twofold. On one hand, we're going to see those who oppose Pitchford's petition for this argument argue, you know what, there shouldn't really be federal oversight. If the trial court made the credibility determination that the prosecutor had a good explanation for wanting to strike a juror and that there was no racial or otherwise discriminatory pretext, there shouldn't be oversight later on, because the appeals courts aren't going to know what the trial judge knew at that time. They're not going to have the same information and 13th juror kind of perspective that the trial judge had. So don't take away what's in the province of the trial judge. On one hand, that would be limiting oversight that SCOTUS has clearly used before because they overturned a similar case. Second reason I think this case is relevant is it's the same prosecutor at trial. So prosecutor Doug Evans, his jury strike choices in Curtis Flowers' trial, one of his trials, was the subject of this argument And again, SCOTUS found it was worth overturning the conviction of Curtis Flowers. Same trial prosecutor at Pitchford's trial. So I think it's very, very relevant information. So again, check that out in the description if you want the quick links to these, or just search for Curtis Flowers SCOTUS arguments and you could check those out. Now, background, because we're not going to hear much when we jump into these oral arguments. We're not going to hear the initial backstory. So all the way back in 2004, Terry Pitchford, he's 18 years old. He and his co-defendant, Eric Bullens, end up robbing a grocery store. This is in Grenada County in Mississippi. The county is 40% Black. That's going to be important because jury selection is supposed to be, a cross-section of the community, the pool that you have available to select jurors from. The store owner, Reuben Britt, was shot and killed by Eric Bullens. Pitchford says, you know what, I was part of the robbery, but I was outside. I didn't fire these fatal shots. I didn't do the murder. And he was convicted in 2006, and he was sentenced. He's facing the death penalty. So, what happened at his trial? So, prosecutor Doug Evans, get to know that name, he used his peremptory strikes. Again, those are strikes where you don't have to give an explanation. And each side has a limited number of peremptory strikes to use, so you don't want to just use them all willy-nilly. And it's different than striking for cause. Striking for cause would be something like, hey, this witness is friends with the defendant or is best friends with the victim in this case. You would strike someone like that for cause because I think all parties should agree probably not going to have a fair trial if that's who's on the jury pool. So it doesn't really count against either of the parties if somebody's stricken for cause. With a peremptory strike, you've got your limited amount, so you want to use them wisely. And typically you don't have to explain why you're exercising a peremptory strike unless someone raises a Batson challenge. So Doug Evans was striking 4 of the 5 eligible Black prospective jurors in the veneer pool for Pitchford's jury, and only struck 3 of the 36 eligible white jurors, 8%. So just a matter of proportions, seems like a disparity on its face, if you ask me. The final jury had just 1 Black member, and again, this is a community with a population 40% Black. 1 Black member, 80% of potential Black jurors in the pool were stricken, and we only struck 3 of 36 white jurors that were in the pool. So for each of these 4 strikes, Pitchford's defense counsel objected, raised a Batson challenge. They argued that these were racially discriminatory strikes. The trial court asked for an explanation from prosecutor Doug Evans, and the standard isn't that high. They don't have to make the most beyond reasonable doubt. It's just a prima facie showing. And ends up agreeing, these strikes are fine. I don't find them to be racially motivated. So I'm going to overrule each of your objections. After that, defense counsel tried to argue more. They tried to say, well, hold on, the prosecutor said this, but we don't agree with that. And the trial judge says, no, we're not going to do that. I'll preserve your objection for the record. We're going to move on. So defense counsel did try to continue the objection and was told it was preserved for the record. They appeal. They appeal this. The direct appeal, Mississippi Supreme Court in 2010. The convictions are affirmed. They held here that Pitchford waived his right to argue the prosecutor's race-neutral reasons were pretextual because he did not sufficiently rebut them at trial. You didn't argue hard enough. So they don't even look at the merits of the claim. They don't make a finding on whether or not they think the strikes were proper or not. They just say, hey, you waived this argument. You waived the argument. And many states have a rule like this. And the way that they lay it out, the way it's applied might be slightly different. But 20 different states filed an amici brief in this case, arguing, hey, please don't interfere with our waiver rules. Don't allow defendants to raise issues on appeal that right now would be considered waived if they don't raise it and preserve it at trial properly. So prosecutors from 20 different states are binding together opposing Pitchford's plea to the Supreme Court here. How did we actually get in front of SCOTUS? So after the direct appeal, we end up taking the route of a habeas corpus petition, which is, you're holding me. You don't have a right to hold the body. So Pitchford files a federal habeas corpus petition in the U.S. District Court for the Northern District of Mississippi. The district court grants relief. The district court ends up granting relief. And then they rule that the Mississippi Supreme Court's waiver determination was unreasonable application of clearly established federal law under AEDPA. And I forget what that stands for, but it's related to death penalty and your rights when you are, facing capital punishment. We'll get the acronym at some point. And that the trial court had failed to properly conduct the third step of the Batson analysis. So when this relief is granted, Pitchford wins at this stage in 2023. The state appeals it, and the Court of Appeals, the Fifth Circuit, ends up reversing this decision. So Fifth Circuit, and you could go listen to those are the oral arguments that are linked in the description. They end up finding that, hey, Mississippi Supreme Court's waiver ruling, it was fine. It wasn't unreasonable. So they reversed this decision granting relief to Pitchford. And then SCOTUS agrees to hear this case on the limited question of whether or not, under AEDPA, the Mississippi Supreme Court unreasonably determined that Pitchford waived his right to rebut the prosecutor's asserted race-neutral reasons for exercising peremptory strikes against 4 Black jurors. So that leads us to the oral arguments that took place yesterday. Let's cue those up. Oh, wait, one more thing. This is, and I actually recommend checking out the docket in this case. There's a ton of, for both sides, in support and opposed to the petition here. There's a ton of amici briefs. So different organizations, individuals even, and then the U.S. government, and then again these 20 states, all filing, asking if their arguments to the court can be considered. This one here, that I think we should read a few pages of, this is from the 20 states. So you're going to see here, let's see, this is 20 states filing as friends of the court in support of the respondents, right? So they're in support of the prosecution here in opposing Pitchford's arguments. So what do they say? What's their stance? And they argue more than one argument. We're going to look at a quick summary of one of their arguments here. This is what the prosecutors in 20 states want. When reviewing a Batson challenge to the use of peremptory strikes, the credibility of the prosecutor's explanation goes to the heart of the equal protection analysis. And once that has been settled, there seems nothing left to review. So once that's been settled at the trial court, that judge, the 13th juror, there's nothing else to review. Don't review it anymore. Because evaluating demeanor and credibility lies peculiarly within a trial judge's province, appellate courts should sustain a trial court's ruling in the absence of exceptional circumstances. Given this framework, it makes perfect sense that many state and federal courts have adopted waiver rules like Mississippi's. These rules encourage claims of purposeful discrimination to be brought and developed before the decision maker best situated to identify and correct discrimination. So here they're saying the trial judge is best situated. Petitioner's anti-waiver rule, so they're calling what Pitchford's asking for anti-waiver. His anti-waiver rule, by contrast, would encourage sandbagging, prejudice the prosecution, and force appellate courts to make an all-or-nothing choice years after the error could have been corrected. So, even if it could have been corrected years ago, the argument here is don't allow the expansion of oversight. Don't, and I would even argue it's an expansion. They're pitching it, they're framing it as if it would be expanding what a petitioner would have a claim for. I don't really think it's an expansion. I think they're framing it as, this isn't allowed right now, don't let them do it, even though I don't agree with that framing. They say some jurisdictions may choose to hear new Batson arguments on appeal, but nothing in Batson or its progeny suggests that course is required or even desirable. We're going to read a little more on this argument. Because I think it's a reach. I think it's a reach. Again, this is not a case where somebody didn't even object. This is a case where somebody objected, tried to continue to object, was told their argument was preserved for the record on appeal, and then the Mississippi State Supreme Court was like, "Oh no, you didn't fight hard enough. Sorry." So, all right. So this argument continues. Again, this is from the 20 states binding together like the Justice Friends. Waiver rules recognize and preserve the singular role of the trial judge to enforce Batson v. Kentucky. So just think of your least favorite judge and consider this argument giving them the utmost discretion, the final word, over whether or not somebody strikes and a challenge raised against those strikes. That decision can only ever start and stop with your least favorite judge. In Batson v. Kentucky, the court interpreted the Equal Protection Clause to prohibit purposeful discrimination in the use of peremptory strikes. Whether a prosecutor exercised strikes with an illicit intent is a question of pure fact that largely will turn on evaluation of credibility. There will seldom be much evidence bearing on that issue, and the best evidence often will be the demeanor of the attorney. Thus, the job of enforcing Batson must rest first and foremost with trial judges. And that's from the Flowers v. Mississippi case that was overturned. And notice the quote here says, "rest first and foremost," but not only. In turn, the job of the defendant must be to present evidence to support the claim to the person with primary responsibility to decide it. A regime that permits piecemeal Batson claims, in other words, claims raised partly at trial and partly on appeal, is strictly inferior to one that promotes complete preservation. If the defendant withholds evidence or arguments at trial, there will never be an opportunity to weigh them alongside the best evidence. The only decision maker who has that evidence, the trial judge, is deprived of the totality of the relevant facts. And what the appeals court gains from the defendant's belated development of his claim cannot substitute for firsthand observations of the prosecutor and the potential juror. To be sure, appellate courts can hear piecemeal claims, but it doesn't follow that they must. And there's nothing in the Constitution or the doctrine to commend a system that promotes piecemeal claims rather than encouraging the fullest presentation possible when the claim arises at trial. And it's interesting because the underlying issue, as I understand it here, is there's no right for the defense counsel to argue until they've exhausted their argument once it's time to rebut the prosecution's response to a Batson challenge. So if they're not it's like a catch-22 they're forcing on defense counsel, is the way I see it. They say, accordingly, many state and federal jurisdictions have adopted sensible preservation rules. These rules fall well within the realm of discretion accorded to lower courts for implementing Batson, and certainly within the realm of reasonability needed to satisfy AEDPA. This is where, again, think of your favorite judge. Think of your least favorite judge. Think of your least favorite judge that seems to have a really good relationship with a sketchy prosecutor. Like, for me, I think a lot of Glanville, Adrian Love. And imagine if this logic, let's hear this logic while thinking of a duo like Euro Glanville and Adrian Love in the YSL trial. Batson entrusts trial judges with the task of identifying racial discrimination. Analysis of Mississippi's waiver rule should be guided by the central role Batson and its progeny have assigned to the trial judge. From the doctrine's inception, this court has had confidence that trial judges, experienced in supervising voir dire, will be able to decide if the circumstances concerning the prosecutor's use of peremptory challenges creates a prima facie case of discrimination. And in virtually every one of its Batson cases, the court has reaffirmed the peculiar province of the trial judge. This aspect of the doctrine flows from the nature of the claim, the differing strengths of trial and appellate courts, and the high price of retrial, years later, for an error that could have been corrected on the first day of trial. So imagine, and for anyone that didn't see the YSL trial, it was not uncommon for the state, for prosecutor Adrian Love especially, to argue and argue until the judge caved in. And when it came to the other side, even though there were 6 co-defendants, right, it seemed like as a whole, the defendants, 6 of them, couldn't get in nearly as many words that Adrienne Love would be able to get in and argue. And she'd be able to rebut and rebut and rebut any time that they did. She always was able to get the last word. The judge allowed it, and the judge would stop the defense attorneys from talking. To the point where Brian Steele at one point, Max Shart, I think at more than one point, but we didn't see it on screen, he did it in emotion, raised an issue with the way the judge would shut them down in front of their clients and sometimes in front of the jury. And it just kind of raises this question where you have 20 states here arguing, no, just trust that whatever got to be in the record is everything the defense wanted to get in the record, nothing more. There's nothing else they can argue on appeal. Yeah, until the ears were talked off the donkey. Exactly that. Exactly that. So we've got very few constitutional claims require the court to probe the prosecutor's state of mind. So they're opposing here, I think this is the biggest issue they have, the same way nobody on the prosecution team ever wants to be put on the stand and go under oath, with the exception of someone like Carrie Morrissey in the Rush trial. Who knows what she was thinking? But, we don't want to expand the reasons, the number of pathways that would allow somebody to make a prosecutor have to explain themselves, what's in their mind. And here we're dealing with a prosecutor's decision to strike a juror, peremptory strike that they typically don't need to explain, until someone challenges it saying, hey, I think there's a discriminatory pretext behind that strike. And here you have 20 states getting together like, don't use this as a way to say that people can get into the mind of a prosecutor. Let that remain sacred. So they say, unlike Brady or Napui claims, which often seek to prove the prosecutor's knowledge by inference, the 3-step Batson procedure forces the prosecutor to articulate a clear and reasonably specific explanation of his or her actual motive for a challenge strike. And they're emphasizing here actual motive, which to me is an implicit argument by these amici that if a prosecutor says so, that's actually what it is. That's how they're writing this. I don't subscribe to that. This feature distinguishes Batson even from other claims of racial discrimination because direct evidence of intent, whether lawful or not, should always be available by conducting step 2 at trial. So if you can't produce whatever your evidence is, there is no other evidence available. There's never a way that you could find maybe notes on an Excel spreadsheet that say, strike this juror because of his race. If you find those notes, if you happen to come across those notes after trials occurred, according to this argument, that should have been available at trial, so can't be evidence now. Can't use it now. Can't bring it in now. So Batson is therefore unique in making one person produce the best evidence on the spot and then reducing the decisive question to whether that person should be believed. So it comes down to the trial judge deciding whether the prosecutor, whatever it is that they articulate as their reason, their motive for striking a juror, it's the trial judge's choice whether or not they should be believed. And these 20 states say that's where the analysis should stop. That's where the oversight should stop. So, because the heart of Batson is the prosecutor's credibility, it should be resolved at trial. The reasons are structural. The trial judge is best placed to consider the factors that underlie credibility: demeanor, context, and atmosphere. And I don't think that this is untrue. But I think saying that this is all that matters is not good. So we've got only the trial judge has the benefit of observing the prosecutor firsthand at the time of the strike, at the time of its explanation, over the course of the proceedings, and on a daily basis in some cases. The judge can watch facial expressions or body language, listen for hesitation, and assess, in a borderline case, whether any hesitation or contradiction reflect deception or the difficulty of providing rational reason for an instinctive decision. Appeals courts cannot, on the basis of a cold record, easily second-guess these observations, so they defer. And that's true. I mean, the appeals court is going to have a text transcript. It is a different thing to look at. The trial judge occupies an even more privileged position when a strike rests on a fine judgment call, such as a comparison of juror responses that differ in only nuanced respects or a sensitive assessment of jurors' demeanor. A prosecutor's reasons will often invoke a juror's demeanor, and the trial judge is best situated, indeed, singularly situated, they're the only one, to confirm that the juror's demeanor matched the prosecutor's description, especially when attorneys strike a juror based on instinct, as they have for centuries. And we have Blackstone commentaries on the laws of England, citing impressions created by bare looks and gestures as valid grounds for a challenge, even without being able to assign a reason for such dislike. Only the trial judge can come close to seeing what may be invisible even to the lawyer. Accordingly, many of this court's Batson decisions have rested on the defendant's inability to overcome the deference owed to the trial judge's credibility determination. And once that has been settled, there seems nothing left to review. But appellate courts sometimes elect to hear new Batson claims or new arguments and evidence not considered below. When they do, there are two bad options if they cannot otherwise deny the claim. One is remanding for the trial court to conduct a Batson hearing. A remand respects the trial judge's better position, having supervised jury selection, and its ability to bring the striking attorney before it to judge his or her credibility and further explore the validity of the various arguments the parties may advance. But a remand adds delay and essentially requires reconstructing the entire voir dire, something that will be extremely difficult even if undertaken soon after the close of trial. In many cases, it may be impossible for the prosecutor to recall the reasons for a strike, let alone the nuanced differences among numbers of the venire. A belated hearing can force the court to decide a Batson claim based on nothing beyond, "I do not remember," from the prosecutor. That courts reach divergent results in such cases is as unsurprising as it is unfortunate, for the unfair prejudice to the prosecution is severe. Let's see. A second, and so you have prosecutors here arguing against a remand when it's something that could be favorable to the defendant, the person that was convicted. So if a trial court reverses someone's conviction, they say, we're going to remand this back down to the court, give the defendant his day to have some relief. Do you ever see prosecutors, should prosecutors, these 20 states, get together and say, you know what, that defendant, even though he has this opportunity to go back down and reweigh it, it's such a high burden, it's so late in time, let's just not retry this. Let's just drop this case. How often do you see the same logic applied in the opposite direction? And so, and I'm not trying to see this in terms of extremes, and I'm not trying to take this argument all the way outside the context of, jury selection, but some of the arguments are like, oh no, we have to ask the trial court to look at things 10 years later. Well, I'm thinking of the Zachary Adams case, where there's been a lot of bullshit that's been unveiled and revealed and really put on the stand because some of the bullshit has come from the trial prosecutor's testimony herself. If the argument is, well, we can't do a redo because it's too late, these 20 states should be more inclined to drop late prosecutions. And they're not going to actually take that logic. So how do you want it both ways? Anyway, they continue. A second bad option. There's no good option. A second bad option is for an appellate court to conduct its own review of the Step 3 circumstances, now raised together for the first time. It is difficult even to understand the nature of this review. They're citing here the Hernandez case. The court must ask whether a trial judge clearly erred in failing to consider facts not brought to the judge's attention. Then it must accord strong deference to the trial judge's credibility finding, again, despite that the finding did not consider the material raised on appeal. Trying to square the circle, an appellate court might imagine that the trial court would have found had it been presented with everything argued on appeal. But that counterfactual question, for the structural reasons described above, is essentially impossible to answer. The trial judge in Ayala, for example, had a somewhat different impression from that of the prosecutor, but ultimately agreed that a prospective juror seemed nervous. How can courts possibly weigh new circumstances raised on appeal against a subjective impression? Or take Collins, where the trial judge was willing to give the DA the benefit of the doubt without having seen a juror roll her eyes in response to a question. It is hard to see how an appellate court, without observing the prosecutor firsthand, could possibly infer the prosecutor lied. It has no way to know whether the attorneys were credible. When a Batson claim is not fully ventilated until appeal, the court's task is even more difficult and speculative than usual, for the appeals court isn't even considering the same factors as a trial judge. In theory, a reviewing court could see new and extraordinarily powerful circumstantial evidence that betrays the prosecutor's aim. But in the absence of exceptional circumstances, there can be no basis to second guess. In addition to the inherent difficulty in answering counterfactuals about credibility on a cold record, a review of Batson claims on direct appeal has the downside of forcing an all-or-nothing choice. Because the trial court is no longer in a position to cure the violation during the jury selection process, the sole remedy remaining is the grant of a new trial, relief that requires an additional and unnecessary expenditure of judicial and litigant resources, since a new trial could have been avoided by a timely decision. What is this saying? Let's break this down. You have the inherent difficulty in answering counterfactuals, even all of that aside. Don't force an all or nothing choice. Because what happens? The trial court can't cure the violation. The phrase cure the violation presumes there was a violation in the first place. But the argument here, the framing of this here is, well, the only remedy of this would be to grant a new trial. And why would you want to do that? Just leave the violation be, because it's too prejudicial to the prosecution to cure the violation. We agree there's a violation, but we don't like that we'd be out of time and resources for you to offer a remedy. And so if it's not cured right away, it's never worth curing. You shouldn't try to cure it later. I think this is ridiculous. I think this is just ridiculous. Yeah, like, should we just have no appeals? And I get that I'm probably looking at this with an extreme lens, but if I don't, if the Supreme Court were to agree with this kind of notion and say, yes, we agree that there shouldn't be remedies later for things that could have been held in a timely manner, it's just such a broad argument. I think it's like it's like literally a straight down slope. It's just a ditch. Like, we're already in it. Like, just SCOTUS, go home. We don't need you anymore. We'll dismantle the circuit courts. We'll get rid of the Court of Appeals. Like, let's just have trials. And when the judge says that we are right as the prosecutors, there's no way to challenge it. So there we go. There's a lot more junk in this brief. There's also a brief of the United States government. They filed an amicus brief. There's a ton. Lots of stuff to argue. But we're going to get into the oral arguments from yesterday. That is the context I wanted you guys to hold as we were going into this. To know what prosecutors really, really seem to be worried about if this decision, like, I don't know. With the Flowers case, the Curtis Flowers case, I don't believe SCOTUS, like, really set a new precedent. I'm pretty sure the outcome of that case was, this is clearly a Batson issue. Like, Batson already exists. It's already case law. It got to us, and we're going to tell you, yeah, this is a Batson problem. And reverse the conviction. But it was kind of one of those things, like, I think SCOTUS felt like shouldn't even have gotten to us. You guys just messed up that badly that what seems so obvious is going to go back down. So let's get into these Pitchford arguments, you guys. Thank you guys for tuning in and listening to my reading. Also, big thank you here, Sheriff Chuck, kicking us off with 5 gifted subs. Let's get some party chucks in the chat, and we will get this going.
We will hear argument this morning in case 24-7351, Pitchford versus Cain. Mr. Perkovich.
Mr. Chief Justice, may it please the court. In the selection of Terry Pitchford's capital jury in 2006, the trial court grasped and conducted just 2 of Batson's 3 steps after the district attorney struck in succession 4 black citizens. Despite the state's assertions throughout the red brief, the judge never determined the credibility of the prosecutor's step 2 proffers. Had the judge done what Batson demands in step 3, the court would have considered, from the voir dire that single February morning, the prosecutor's absence of questioning about the issues and the proffer's lack of record support and irrelevance to the case. What is more, proper credibility determinations would have concerned numerous extreme bad faith findings against this district attorney in 2 Mississippi Supreme Court capital reversals published in 2003 and 2000, which held this prosecutor had fabricated prior statements to impeach 4 witnesses who were black, and in closing argument espoused 14 discrete lies about the record. Instead of abiding Batson, Pitchford's trial court careened to opening arguments. When the defense strained to be heard before the jury's impanelment, both about Batson and a fair cross-section challenge, the judge assured her 3 times the Batson objections were preserved. Yet the Mississippi Supreme Court found that Pitchford's defense failed to rebut the proffers and thus waived argument, while deeming the merely race-neutral proffers as, quote, acceptable, a pale substitute for Batson's demands, and a sidestep of the trial court's failure to determine the credibility of the 4 strikes. The trial court's unrectified failings in this prosecution, also riddled with other misconduct, yielded a jury selected with discriminatory taint, which in turn condemned an 18-year-old whose accomplice, according to the state's case, killed the shopkeeper in this botched robbery. We urge this court to reinforce the Equal Protection Clause's guarantees for defendants, as well as citizens willing to accept the awesome responsibility of jury service. I welcome the court's questions.
Did trial counsel make those arguments?
Mr. Justice Thomas, which arguments specifically do you mean?
Did the trial counsel make the argument that the prosecution discriminatorily picked the jury or exercised peremptory strikes for the reasons you just stated?
Justice Thomas, trial counsel made the objection timely.
What was the objection?
It was a Batson objection.
Okay. And did the trial counsel has the burden of demonstrating discrimination, right?
Justice Thomas, that's correct.
So did trial counsel do that?
Justice Thomas, trial counsel attempted to engage that process, which entails 3 steps in burden shifting. Unfortunately, the 3rd step did not occur in this case, notwithstanding trial counsel's effort.
What do you mean by that? It didn't occur. The judge decided that it was race neutral.
Respectfully, Justice Thomas, yes, that's all the judge did.
But did the trial counsel offer an argument or evidence that the reasons offered by the prosecutor were pretextual?
Justice Thomas, as the veneer was being released from the court, trial counsel sought to be heard on Batson and a fair cross-section issue, and was told by the trial judge repeatedly that her record was preserved.
But didn't trial counsel subsequently file an affidavit indicating that she did not raise these objections?
Justice Thomas, yes, that's correct. 3 years after the decision that's before the court now, in state post-conviction, an affidavit supporting an ineffective assistance of post-conviction counsel or trial counsel was authored, which hews very closely to the decisions before the court. It just mirrors what was ruled by the state Supreme Court in 2010.
What the transcript transcript shows is that Ms. Steiner's, what she said is at some point the defense is going to want to reserve both its Batson objection and a straight 14th Amendment racial discrimination. Was that objection raised later on? I mean, I think that's where, that's the preface to where you say that 3 times the court said you have that. And I wonder if there was some confusion between the reference to at some point the defense is going to want to reserve and the court's statements that it is, you've already made it in the record. So I am of the opinion that it is in the record.
Mr. Chief Justice, thank you for that question. It allows me to clarify the sort of the goalposts on this question under Mississippi procedure. When the veneer is dismissed and the jury's impaneled, the opportunity to challenge Batson essentially ends or does end. Of course, there are post-trial motion practice that can occur. So the relevant time for this to be addressed, which the defense counsel was aware of, and that's why she strived to speak to that issue in a separate fair cross-section issue when it was still relevant for the trial court's decision. So I don't think that the defense counsel was seeking to sort of put a marker to be able to return to it, because there's really, that was the point of no return for the judge.
Well, but she did say at some point she's going to want to reserve. I just wonder if that's a source of some confusion for the judge, or what we're supposed to do with that potential.
Well, Mr. Chief Justice, I think if you see sort of as the colloquy goes down the page, with, as you pointed to, it's clear in the record 3 times. Then the judge turns to reiterating his ruling, which again is merely a step 2 ruling as to race-neutral findings. And he says, so there is no Batson violation, drawing a line under the Batson colloquy at that point, and then shifting to the other issues, meaning that fair cross-section challenge I spoke of.
Could we interpret at some point from the defense counsel as an indication that she was preparing or prepared to make the showing, and she was asking the court for the opportunity to do so?
Justice Jackson, yes, I think that that is the fair reading and an unmistakable reading of this record.
It does indicate that she was suggesting that she would like to do something. It wasn't as though she felt as though the Batson objection was already, or at least her arguments were perfected. And it sounds to me from the transcript that the trial court was cutting her off, was not giving her a chance.
Yes,
was maybe mistakenly saying that it had already been done.
Yes, Justice Jackson, if I could pick up on that last point, I think the cold record here, and it is a cold record we're working with, of course, indicates that if you look at page 168 in the JA in terms of that initial colloquy when the Batson challenge is raised and then Miller L is invoked, the judge is sort of reflecting a disorientation to what the Batson inquiry holds, which is 3 steps. He is speaking to the race-neutral proffers that correctly are the second step, but he's unclear whether this goes to all of the stricken veneer members or just the black stricken veneer members on 168. And so you fast forward to the proffers that are put forward by the prosecutor, and you see in rapid fire within a page the finding race-neutral, 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 race-neutral. Let's return to striking the jury, and the court instructs the defense to continue the peremptory strikes. And so at the first moment where there is an opportunity to speak to this, defense counsel returns to the issue and seeks to be heard on it, and as noted, is told 3 times in a row. It's clear in the record, and then a reiteration of the ruling.
After the point that Chief Justice raised, at some point the court responded, "You've already made it in the record. Some of the opinion it is in the record," and then the defense counsel says, "Well, I don't want to let the paneling go by without having those objections," and then the court says, "I think you've already made those, and they are clear in the record." For the reasons previously stated, the court finds the reasons were race neutral, right? So that it continues on. I guess how we read that confusion is critical to whether there's a waiver here or whether it was unreasonable to find a waiver here.
That's right, Justice Kavanaugh. And of course, that addresses the D2 considerations in the case, and there are legal implications as well in terms of the mishandling of this. But reading that record and determining whether this is a reasonable determination that this defense counsel on this transcript had forfeited or failed to rebut when her effort to be heard on the matter was clearly addressed. And so
Counsel, in the post-trial motion that was made here, the jury was impaneled right after the exchange the chief made, so there was no time to make a record there.
Yes.
In the post-trial motion that was made by petitioner's counsel, I believe she did raise a Batson challenge, and she did raise the pretext argument directly, didn't she?
Justice Sotomayor, that's right, and that's very salient because that is, on this record, the first opportunity meaningfully to speak to the pretext question and comparison issue, which
once the judge decided to panel the jury, the only time really to raise it again was on post-trial motions.
That's correct, Your Honor.
And she did. She said the reasons were pretext, given, I don't have the exact language, or maybe you have it memorized, but given the voir dire was similar, they gave answers similar to the general public, to the other people in the pool, correct?
Yes, Justice Sotomayor, and that's drawing from questionnaire responses because there was no voir dire to speak of the stricken individuals here.
Counsel, can I ask you how you think that the voir dire or the interchange, between counsel and the judge should have gone? One thing I find challenging in reading the transcript, it doesn't record pauses, right? It doesn't record seconds. And so if we had a transcript here where the judge said, sit down, counsel, I don't want to hear anything more from you, that would be a lot clearer, right? I mean, but we're in D2, so, the state's getting a lot of deference here. What do you think the judge should have done?
Justice Barrett, what we see commonplace in our courts is the court turning to the defense and offering the floor in some fashion. Agreed, we don't have sort of an audio recording. We can't sense whether there's a pause here, but I think the context is really important. And this is a jury selection process with a voir dire that took about 3 hours. To put it in context, the Miller L case, obviously it's really important here.
But you're not really answering my question. When she raised the objection, when she said she wanted to preserve it for the record, all she had done at this point, I mean, you're right, there are 3 steps, but so she raised the Batson objection, the prosecutor advanced the race-neutral reason, and she had the opportunity to impeach that reason, essentially, right?
Respectfully, no, Your Honor.
Well, let's see. That would be the 3rd step. What you're saying is that the judge cut her off before she reached that step, correct?
Yes, Your Honor.
I mean, I understood the fair cross-section point to be part of her effort to impeach, not just a distinct argument. Am I understanding that wrong?
Justice Barrett, I'll point you to JA 161 through 163, where there is a submission of this fair cross-section argument.
So she wasn't making that point also in reference to the Batson?
There's some overlap because of the general issue with the jury, but it's a discrete challenge. And that shows up in the appellee's brief and the ultimate decision.
Okay, so I guess here's my specific question. If you could tell me what you think the judge should have done, because she raises the objection. The prosecutor offers a race-neutral reason.
Right.
She does raise, I mean, she speaks up, so she's able to make this cross-section point, which goes to, you say, there's some overlap. Should the judge there have paused to, I mean, so is the idea here that the judge should have paused and said, do you have anything further to say to show that this was pretextual?
Justice Barrett, there's sort of 2 junctures here within 5-6 pages of the JA that are important. The first are after the race-neutral determinations are made, the court then immediately instructs the defense to start striking the jury with the panel that's in the box. So after that's done and before the veneer is dismissed, or as the veneer is dismissed, the defense attorney returns to the issue and seeks.
But did the defense attorney have an obligation to speak up even at that other point, and at the first point you're describing, and say, this is why I mean, usually we expect lawyers to assert their points, to assert their objections. So I'm just wondering, does the judge have an obligation to stop and elicit a response? Or is it the defense counsel's burden to, because the defendant bears the burden of proving the Batson challenge, right?
Yes, Justice Barrett. In a situation where you have 4 strikes that are being addressed in succession, and the court elects to deal with the step 2 all in a row, it would be reasonable and certainly kind of the only way to encounter what's transpiring in that back and forth between the prosecutor and the judge to expect that step 3 will occur after that.
But did defense counsel have an obligation to raise the point?
The court has an obligation to conduct step 3 in the first place. The burden of persuasion remains with the defense counsel throughout all this, but it also coexists with a parallel duty that the trial court has to make its determination and critically.
So are you returning to the argument which was addressed, the Fifth Circuit got to this point that you're saying that the trial court made no determination about whether there was a Batson finding?
Yes, Justice Barrett, that's what this record reflects. Yeah.
Counsel,
Perkovich,
I think if you look at Perkett, Hernandez, and
Yes.
Shiner, they answer Justice Barrett's question in that the obligation is on the trial judge to make a finding on step 3, correct?
Yes.
And
To clarify, though, I agree with that.
right.
I was just talking about the argument about.
yes, no, and my follow-up to that was, I think what you're saying, given the transcript, is I think the judge believed he only had to find a race-neutral reason because he says that at the very beginning of this process. He says, all I have, at times, a lot of times on Batson, I just have the state give race-neutral, I'm assuming he meant race-neutral reasons, as to all. And she says, I think the jurisprudence simply states the court must make a determination on the basis of all the relevant circumstances to racial discrimination. The judge then says, I'll have the state give race-neutral reasons. And after each race-neutral reason is given, he then asks for the next one, and the next one, and the next one. And I think your point is he never pauses to give her a chance to address pretext, correct?
Right, Justice Sotomayor.
Or for him to make the required third step finding.
This is an exchange between the prosecutor and the trial court for all 4 of the step 2 steps.
Mr. Perkovich, what happened here is certainly not a model to be followed in future cases. But I wonder if you would agree that in interpreting this transcript, we can take into account the way defense counsel generally behave in a situation like this.
Justice Alito, if you could clarify that question of defense counsel's general behavior.
Well, this is the most timid and reticent defense counsel that I have encountered. Any competent defense attorney that I knew would have spoken up. Let's take this, take this example. This is on 169, juror number 30. The prosecutor is called upon to give his race-neutral reasons. He says she has mental problems, according to a police captain. They've had numerous calls to her house and said she obviously has mental problems. And then the court says that would be race neutral as to that juror, and nothing is said. I mean, with respect to all of these jurors, all the defense counsel I have known would be standing up and say, Your Honor, that's a pretext, and so forth and so on, to make clear that the point is driven across to the trial judge. I don't understand what happened here, unless, well, anyway, I don't understand it.
Well,
Just
Justice
pounding the table.
Alito, I think the fact that this is sort of a 2-person conversation, very clearly from the record, and that these strikes were clustered, reflected what was going on in that courtroom with the judge just addressing the steps in succession, I think the reasonable expectation is that defense was going to be heard, and that third step just did not happen. Rather, the court instructed her to strike her panel, and she returned to this once there was that opportunity that we've already discussed.
Yeah, but I know, trial lawyers have to have a certain amount of toughness, and she had every opportunity. And the judge didn't handle this the way it should have been handled. The judge should have said, okay, that's your reason, defense counsel, what do you have to say, if anything? That's what should have been done, but really, she had every opportunity to make her point, and she didn't. It's not a case where the judge said, shut up, sit down, I'm going to hold you in contempt if you say anything more.
Justice Alito.
But it could have gotten to that point. So
It didn't get to that kind of pitch, certainly. However, the way this rush process occurred throughout the whole morning, culminating in the strikes, as I was starting to answer Justice Barrett, in context, the Miller L. voir dire took 5 weeks with a veneer that was 108 people as opposed to 96. So the rushed nature of this, I think, informs how we make sense of this record. Another example of how rushed this was, because I think the judge was very sensitive to the sequestered jury's hardship. The liability phase ended a day earlier than expected, and afterward, counsel sought to have a continuance of a day because their single expert was subpoenaed in Texas. The judge denied that and forced counsel to proceed without their single witness.
I appreciate all of that. And I understand this was not a model by anybody's stretch of imagination. But I didn't see where the defense counsel even mentioned the word pretext to the court anywhere in the transcript until after trial.
Right.
And given that, could somebody read this as saying, I don't have a pretext argument, I mean, we're on, as colleagues emphasized, we're under D2, so we're not asking, did she waive? We're asking whether the Mississippi Supreme Court any reasonable jurist could reasonably conclude that she waived the argument by not mentioning even the word. How do help me with that?
There's a fair amount to unpack there, Justice Gorsuch. I'll try with the waiver question as sort of the end of this process. So before that is a finding, determination from the Supreme Court that there was a failure to rebut. And again, the effort is to be heard. The response from the court is, this is clear in the record, and then the lines drawn under Batson, and a shift is to the other issues. So the moment of truth for that was then, and as Justice Sotomayor pointed out, in the motion for new trial, that was the first sort of opportunity in terms of the basic procedure here to speak to that, which was done. Now, the D2 point is critical here, but also there's a D1 implication in this breakdown. And
well, help me with the D2, because that's what I'm struggling with at the moment. We have to decide whether the Mississippi Supreme Court made an unreasonable determination of fact. The determination of fact here is that she waived, or really more accurately forfeited. Yeah, it's her burden. We all agree on that, to raise pretext. She didn't raise pretext at all.
I'm a little confused by this argument, and I'm not a lawyer, but in my mind, from what I understand, when you object, when you raise a Batson challenge, that's inherently an objection calling for the court to inquire with the prosecution for an inquiry into the pretext for the strike that they just made. So the argument here is you literally have to say the word pretext. Otherwise, you're not really asking for an inquiry into the pretext behind a strike. I don't follow that.
Well, Justice Gorsuch, if I may, so there is a burden of persuasion that sticks with the challenger, the opponent of the strike, and that's the defendant. There's also a duty that the court has, and that's first and foremost here.
I appreciate that.
And that duty is twofold, and that is to make a determination, irrespective of what's pressed by the advocate, And so there is a parallel sort of decoupling of it. That is really important
You
here.
could find no Batson violation if there's no pretext argument made, right?
Respectfully, no. Actually, the cases are quite clear in that regard.
If the plaintiff says, sorry, the defense lawyer says, I don't have a pretext argument, Your Honor,
Well, that would be...
then there's no finding required on pretext, right?
No, Your Honor. Actually,
there's no Batson violation, wouldn't you?
the burden of persuasion is with the opponent of the strike, clearly. And if the strike effectively expressly waives in that scenario,
No.
the court still has...
We have step one. Step two comes, the government's lawyer comes up with race-neutral reasons. Step three, suppose the defense lawyer says, I have no pretext argument, Your Honor.
Since the inquiry is made to step three, the trial court still has a duty.
Sure, to say no Batson violation.
Isn't the duty to look at the totality of the circumstances to determine whether or not the defendant has carried their ultimate burden of establishing discrimination? So it may be that with respect to that particular aspect of the back and forth, the defense counsel doesn't have an argument, or they say, I don't have an argument. But that, I think, is not the sum total of the court's obligation to rule on the Batson objection. The defense counsel didn't withdraw the Batson objection. Right. They just didn't make any argument with respect to pretext.
To be clear, I appreciate all of that. And I appreciate that the court has to make a determination. But the court here did make a Batson determination. He said, I find no violation. Now, maybe that's wrong, okay? Well, and I acknowledge it. It's a muddled record, but he didn't say, I find no Batson violation at the end of it. Now, well, maybe that's insufficient, but that's not what's before us. What's before us is was there waiver? Well, and help me with the D2 thing. I really want some help on that.
I'm trying, Justice Gorsuch. But the key thing here is that his understanding from this record is of two steps. In other words, the equation is race neutral equals no Batson violation. It completely elides the duty he has to do two things, right? Once the case shifts to step three, the court has to afford an opportunity for the ultimate burden of persuasion to be met and make a determination, whatever is said, in pressing that burden of persuasion. Those things exist in parallel because the Equal Protection Clause is implicated here, because there are concerns that are greater than the defendant's, the stricken veneer member, the public's interest. And so all of that was jettisoned here. And I think it's simply because he was unaware of it, at least in this trial.
Thank you.
Thank you, counsel. Justice Thomas, anything further?
Justice Gorsuch asked you what would happen if the defense counsel said, I have no pretext, no refutation, no argument on pretext. And you said that there was more that the court was required to do in making the determination. What exactly is that? What do you mean by that?
So, Your Honor, it's incumbent on the trial court to assess what is before the court.
So what is before the court? You've got the initial assertion, you've got the race neutral from the prosecutor, and you have a defense counsel who says, I have nothing. So what else is there?
Justice Thomas, you have a prosecutor who failed to question on the reasons that he put forward as his proffers for these strikes.
Were those challenged by the defense counsel as pretextual?
As we've discussed, Justice Thomas, she did not speak to it after the step two proffers, and that's one of the failings in this record. There was not an opportunity after the step two proffers were made and before the Batson challenges were overruled to speak to that.
So you used Miller-El, which brings back a lot of bad memories.
Sorry.
You used Miller-El as your model, but didn't the defense counsel there challenge the race-neutral assertions?
Justice Thomas, there is a radically different record in Miller-El from here, as mentioned.
Now, just that the only portion I'm interested in is whether or not defense counsel whether or not defense counsel there argued that this was pretextual.
In Miller-El,
Yes.
there were days of opportunity to address each of the strikes. There was individual voir dire of each of the stricken members. There was a Batson hearing held dedicated to this whole inquiry.
Is that because the defense counsel challenged each of the strikes?
Well, no more than was done here, Your Honor. There's no question that the Batson challenge for the 4 strikes in question here was timely, never waived, never withdrawn.
Let me ask you, we're focused on these strikes. Did the defense counsel make strikes, peremptory strikes?
No, Your Honor. And one reason for that is because, I misspoke. Please bear with me. No, they did. They certainly did.
And how many?
I believe it was 11.
And what were the races of those who were stricken?
I believe they were white, and you have to also realize that the veneer was white for the balance of the strikes that they exercised. So there was no other.
And how many were stricken by the prosecutor?
7.
And what was the racial breakdown?
3 to 4.
Justice Alito?
Well, I want to understand exactly what you think has to happen in a situation like this. So the prosecutor, the defense counsel says, I object to the peremptory challenge of this juror, and the trial counsel turns to the prosecutor and says, what is your reason? I think the prima facie case has been made. What is your reason? The prosecutor provides a reason that's race neutral and is a reason that almost every prosecutor would find is a good reason for peremptorily striking a juror, such as here, one of the jurors, he has a brother that has been convicted of manslaughter. And considering that this is a murder case, I don't want anyone on the jury that has relatives convicted of similar offenses. So it seems legitimate on its face. Now, maybe it's not, and so then the trial judge turns to defense counsel and says, defense counsel, anything to say? And defense counsel says, nothing to say. Now, what about there? Is that, and then the judge goes on. Is that a Batson violation?
Justice Alito, in that hypothetical where the court actually turns and solicits input, that would probably be a waiver on that scenario. What I want to point to with respect to the proffers and family members listed in the questionnaires as implicated in the criminal legal system, the important thing to keep in mind here is that if that was a sincere concern, it would strongly suggest there would be questioning about that, because not only are the various stricken veneer members implicated in that,
Yeah,
but
okay,
others.
I understand all that. Did defense counsel have the opportunity to question these witnesses? I mean, these jurors?
Yes, Your
During
Honor.
the voir dire. So the defense counsel could say, well, look, he's been very, he's happy to have these white jurors who have similar records. Then the judge has to make a finding. But if the defense counsel doesn't say anything,
Justice Alito,
what is the judge supposed to do?
Justice Alito, my response to your last question was there was questioning during the group voir dire. There was no questioning at that point after the proffers were made. And again, very legitimate concern in principle, implications in the criminal legal system. However, if that's a sincere concern, there's going to be questioning about it. And I think if we look at Miller-El, there's a classic example of why, and that is with the field strike. In Miller-El,
Well,
you have somebody.
I understand, but your argument is that even in the example that I gave you, where the judge says, "Defense counsel, do you have anything to say about this?" and defense counsel says, "No, nothing to say," that is not, that there could still be a violation.
No,
there?
I'm conceding that, Your Honor.
So then the question is, how do we interpret this record? Suppose that the judge doesn't actually say that, which the judge should, but suppose defense counsel, as Justice Barrett was hypothesizing, could happen in some case, defense counsel and nothing is said, or there's a pause and nothing is said, then what?
Well, if there's a pause and nothing is said, then that's a different record from what we have. To return to the sort of these legitimate seeming race-neutral reasons, again, the disinterest in questioning on any of the reasons that are offered there has been repeatedly recognized by this court as denoting a sham. In fact, that's language in Miller L. and Snyder as well. And so, it's not that that's not in principle, legitimate reason. It's that it's not explored, because often when it is explored, what comes to light in that process is that the family member really has no connection to the situation, and it's not disquieting for the prosecution, and they wouldn't use it as a reason.
Of course, yeah, but that all is triggered by defense counsel standing up and saying, Your Honor, I object. That's a pretext. The prosecutor has not applied that rule to white jurors.
Well,
all that was required.
Justice Alito, I'm referring to the duty that the court has, whatever is advanced in terms of the burden of persuasion that the opponent has. The court still has to be aware of what has transpired in his courtroom and what has come forward in voir dire, what has not come forward in voir dire in terms of questioning, the irrelevance of the proffers to the case, the absence of record basis. You have proffers here, mental problems, drug problems. There's nothing in the record on that. And so the court just takes that on face value, and that's not the job. The job is to consider all the circumstances and to discredit proffers that are put forward without a basis in the record. None of that
So if
happened.
the prosecutor says, I'm striking this juror because she has mental problems, and the defense counsel says nothing in response, the trial judge has to say, well, wait a minute, you're just telling me the police captain says that she has mental problems. They've been to her house many times. We have to have the police captain come in here. Even though the defense counsel hasn't said one word, we have to have the police captain come here and question, or the officers who made the visits to the house. Is that what you're saying?
Justice Alito, those officers were in the courtroom under subpoena first. So, and again, I return to the fact that—
I'm just trying to understand. I don't want to prolong this. I'm just trying to understand what you think had to happen here. And your first answer was, if defense counsel says nothing, this is my understanding of your first answer, if the defense counsel says nothing to say, Your Honor, the judge can simply say, okay, fine. I find that it's not a racially based challenge.
Justice Alito, as I've been trying to advance, there still is this duty for the court to consider all the circumstances bearing on racial animosity in this record and to make an assessment, whatever is advanced here. And obviously our cardinal sort of point here is that on this record, you have a defense counsel seeking to be heard on this, and the response from the court is, your case is in the record, and I'm going to reiterate my ruling.
I understand that.
Okay.
Justice Sotomayor?
Going back to that point, what's clear from the record here is as soon as he exercises a challenge against the woman with mental problems, the prosecutor then says, the next juror, juror number 3, she was juror number 2, and the court interrupts and says, that would be a race-neutral, again, reason as to that juror, meaning the mental juror. And the prosecutor immediately goes to S3. So there's no pause there.
None.
No pause between the 4 jurors and the race-neutral reasons. So there's no chance for the defense attorney to say anything, correct?
That's right.
Now, you get to juror number 4, the same pattern. Juror number 5. And then he gets to the last juror that's being discussed in race-neutral reasons and immediately says to her, you have to start with jury selection.
That's right.
Again, there's no pause to say, do you have a response? When you're saying to Justice Alito that defense counsel should have asked questions of the jurors, she was never given an opportunity, you're saying, because the prosecutor never did any voir dire of these jurors.
Right.
So she had no way of knowing that any of these things bothered the prosecutor, correct?
That's right, Justice Sotomayor. As I pointed out earlier, the proffers were not questioned. So the only questioning that this prosecutor did of consequence was to do death qualification, which resulted in the decimation of the black veneer. So you have a concentration of questioning, JA 95 to 104, where in rapid succession he's questioning, I think, 37 different veneer members, 28 of them black. to elicit responses that lead to cause strikes. That's the level of questioning that's going on in this record. There's essentially no individual voir dire at all. There are 6 individuals who are questioned near the end of voir dire, and it transpires on a single
Defense counsel
page.
can't be faulted for not knowing what the prosecutor was worried about.
Exactly.
And asking questions. Now, going to the question that at no point did the justice say, did the judge here say, I'm doing step 3 in any way, that these were not pretexts or that I find them to be both race neutral and not race-based, correct?
That's correct.
Now, that's your prong 1. And Justice Gorsuch asked, I think, was asking you whether the judge made an implicit finding. Mm-hmm. The only place I find that potentially is where he says, for the reasons previously stated, first, the court finds there to be all the reasons were race neutral as to members that were struck by the district attorney's office, and so the court finds there to be no Batson violation. That's not an implicit finding on step 3, because he's still relying simply on the race neutrality, correct?
Yes, Justice Sotomayor.
So there's not even an implicit Batson finding on step 3.
Yes, I don't see how you can read that and take away the suggestion of anything more than a determination of race neutrality. And as I've tried to emphasize, there is a very big difference between race neutral and credible. And that court has to make a credibility finding, no matter what else happens in that courtroom.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Just on Justice Thomas's and Justice Gorsuch's questions, if the trial judge had said, do you have any response? And they'd said, we have no pretext argument. That's the essential equivalent of withdrawing the Batson objection. At least that's my view.
Yes.
But what happened here, I gather, your position is, and what Judge Mills, the district judge in the habeas case, found was, Judge Mills said, perhaps Pitchford's counsel should have been more assertive, but the court will not fault them for failing to present specific arguments on pretext when the trial court appeared to have been resolute in its brusque determination that no violation had occurred. In other words, there was never an opportunity. Now, the question is whether that, whether what happened in the trial court was an unreasonable, whether it's unreasonable to find waiver, I guess, or how you analyze the trial record. But the point is not that the trial counsel said, oh, I have no pretext argument, correct? Would you distinguish those two things?
Yes, Justice Kavanaugh. So what we have is trial counsel seeking to be heard, right, before it's too late. As the veneer is being dismissed, exiting the courtroom, the jury's about to be impaneled, that's when she's seeking to be heard, and she's rebuffed 3 times by, it's in the record, it's clear in the record, there is no Batson violation. And let's turn to the other issues, the fair cross-section issue. So she's striving to be heard, and then ultimately she's reasonably relying on the court saying it's in the record. And this is in a context where she raises Miller L., which had been decided about 6 months before this trial, wherein clearly the ability to press a case on appellate review was the letter of the day. So she's relying on what the trial court is saying, that this issue's over, and the trial is moving forward, and opening argument is going to happen in a moment.
What do you think about the Judge Mills' comment, perhaps Pitchford's counsel should have been more assertive?
I think that first, that's a not unfair criticism. We've all seen records where there's more hurly-burly, let's say, and elbowing. But the point is that she timely raised the objection. That's her duty. There's not a continuing objection requirement. There aren't authorities supporting that. And she sought to be heard before it was too late. And then at the next moment, as Justice Sotomayor pointed out, where she could address these issues in the motion for new trial, that was done. adequately so. It was fit for purpose in terms of the motion for new trial. So if the judge was actually concerned about these issues, he had an opportunity to take the case back before it was up on appeal.
Thank you.
Justice Barrett?
I have a few clarifying questions, excuse me, about your position. One, are you asking us to revisit Ford insofar as it said that a state has the flexibility to adopt procedural rules for the assertion of Batson objections?
Justice Barrett, certainly no. That I would point out is dicta, though. Ford was a case where...
So you are asking us to say something different? Or do you agree that states have the right to come up with rules of forfeiture even for Batson objections?
Justice Barrett, certainly the implementation's left to the states. And as we've seen in Johnson versus California, where there was a step one issue that California had, there can be problems in that. And what we have here with respect to step three and this particular ruling on waiver and the failure to rebut being the predicate for that is an example of faulty implementation.
But you're not challenging the state's ability to set forfeiture rules and to say that if you don't make a timely objection, you forfeited it. I'm asking you as a general rule. I understand your argument that she wasn't given a fair opportunity here. I'm not asking about that right now. I'm just saying you don't disagree, do you, with the fundamental proposition that a state can establish procedural rules requiring the timely assertion of Batson objections?
Justice Barrett, the last formulation you gave, I would agree with. Certainly.
You would agree with that? Great.
The very last formulation, though.
Okay, thanks. The other question I have, it's a little bit difficult to tell at some points in your brief. I read your brief to maybe be taking the position that an appellate court has an obligation to conduct the Batson analysis, even if it wasn't made below. So, for example, that the Mississippi Supreme Court here actually had a duty to conduct the comparative juror analysis?
Well, I think the first point here is that the understanding of its own law for Batson was that it could not, right? And that it was unable to consider arguments pressed for the first time on appeal, especially in a context where the first opportunity to do that was on appeal. That's a problem. And so it's that fundamental misunderstanding of this court's law and that basic gateway role at the outset of the appeal that is the first problem.
So what is your position? That an appellate court has the discretion and should understand itself to have the discretion to consider it for the first time on appeal, but not an obligation to do it?
Justice Barrett, this court's holdings have relied repeatedly on comparison that's been pressed in the first place on appeal.
But is it an obligation, or do you just have the discretion? Just pick one.
Justice Barrett, I'll pick discretion with the caveat, though, that the language of this court is a must. Right?
So is it obligation or discretion? Must sounds like obligation. It's just not how I read our precedents.
Right.
So you're asking for us to take those precedents, if there's any ambiguity in the precedents, or to take them a step farther and to say there's an obligation?
I think that the precedents have to be surmised from what the court is doing and how it's getting to the results in terms of the holding for clearly established law. And what the court has done routinely is take argument, comparative analysis that's really not viable in most trial settings and hear that on appeal in the first instance because of the concerns I was speaking to earlier.
Okay. So do you think we have what we need if we were to conduct that comparative analysis now to find a Batson violation now?
I think, unfortunately, that was the ballgame for the state Supreme Court. And they elected not to do that. They had, in that fork in the road, they could have taken what was submitted on appeal and make a merits decision,
so there was sufficient evidence in the record on the comparative juror point, the comparative juror analysis. It's your position that the record is there, and the Mississippi Supreme Court could have, based on the record before it, or that we could now say that there was a Batson violation based on what was introduced about comparative juror analysis on appeal.
Justice Barrett, yes, it was incumbent on the Supreme Court to take that comparison analysis or remand it to the trial court to conduct.
But is it your position that that comparative juror analysis is sufficient, that it was there and the Mississippi Supreme Court had what it needed to find a Batson violation based on what you had?
Yes, Justice Barrett, and the court had done just that in other cases.
Thank you.
Justice Jackson?
So I'd like to get your reaction to what I hear your argument as, and I just want to make sure I've got it straight. That the making of a Batson objection at the beginning of this process actually triggers duties on both the parties' parts and the court's part. So obviously you make the objection, and then we say at step one, the defense counsel has the duty to establish whatever the prima facie case is. The burden then shifts, the duty becomes the state's to offer race-neutral, non-discriminatory reasons. And then ultimately, there is a duty of the court to actually resolve the objection. So the initial Batson objection. So to the extent that people have asked what was supposed to happen here, I suppose if we're in a world that Justice Thomas posits, if the defense counsel, when we get to step three, the trial court says, counsel, and defense counsel says, Your Honor, I have no argument on pretext. Well, first of all, you would, I think, expect the court to say, so are you withdrawing your Batson objection, counsel? I mean, Justice Kavanaugh says, well, that's sort of implicit, but I think the court, because it has a duty to resolve the objection, has to be clear about whether this thing is still on the table once counsel affirmatively says, I don't have any pretext evidence. So right there, we have a problem with the court not clarifying whether this objection is still live in the world of even asking. But in the world of not asking, not asking the defense counsel whether there's any pretext evidence, you would still have the court have to resolve the objection, right? I mean, and you would expect the court to say something like, hearing no evidence or argument related to pretext and seeing no basis in this record for determining that the prosecutor's race-neutral reasons were pretextual, I find that there is no race discrimination or whatnot, right? Like the court has to make a finding that indicates that it's actually resolving the objection on the basis of all of the evidence presented after all of the steps. And it seems to me that there's kind of like a problem here. The lack of clarity is a problem for the court because it suggests that the court did not fulfill all of its obligations triggered by the initial Batson objection. Does that comport with sort of what you're trying to say, at least about what the court's duties were here?
Yes, Justice Jackson. Again, counsel has a duty to press the case and the ultimate duty or burden of persuasion, but that's simultaneous with the duty that by the time this gets to step three in the burden framework, it remains with the court to do the things that you've outlined.
And the court can say there's not evidence that there's discrimination here, you haven't presented anything, et cetera. But here we have a court that's seeming to keep the defendant from making her presentation. So I don't understand how the court could have fulfilled its obligation to look at all the evidence if it has prevented essentially one party from presenting. Let me just ask you another final question. I see this also as possibly a very short opinion. When we look at what Mississippi's Supreme Court said, it would go something like Pitchford's trial counsel made a Batson objection and re-raised it multiple times. Each time, the trial judge reassured her that it was preserved. Nevertheless, Mississippi Supreme Court said it was waived. That's unreasonable. The end. What would be wrong with that?
Not anything I can think of. I mean, we could say more because with respect to D2, obviously, there is a breakdown in that fact determination that becomes a waiver under the Mississippi rule. With respect to D1, another way to look at this is a case that I don't think this court has seen where it just sort of falls off the ledge at step two. And so that's a D1 failing categorically. There's just an absence of that step being taken for the reasons you've outlined.
Thank you.
Thank you, counsel. Mr. Stewart?
Mr. Chief Justice, and may it please the court. In Flowers versus Mississippi, this court faced an extraordinary case and ruled against the state. This case is also extraordinary, but in a very different way that requires a very different result. Start with the facts in D2. Petitioner claims that the state Supreme Court was objectively unreasonable in finding that he waived his pretext arguments. As petitioner once admitted, that is wrong. Years ago, petitioner declared that he failed to, quote, properly challenge, litigate, and preserve, end quote, his pretext arguments. Petitioner also now claims that the trial judge thwarted his efforts to argue pretext. Years ago, he said the opposite. He declared that he, quote, made no attempt to rebut or otherwise offer argument or evidence, end quote, on pretext. In short, petitioner once declared that the facts are X. He now declares that it is objectively unreasonable to find that the facts are X. That is extraordinary. Now take the law. In Ford versus Georgia, this court ruled that lower courts can adopt timely preservation rules to implement Batson. Many courts have done that and adopted a waiver rule like the one applied here. Petitioner ignores Ford versus Georgia. He never cites it once. And he asks his court to declare that a rule adopted by most federal courts of appeals is not just wrong, but objectively unreasonable. That is extraordinary. Petitioner also claims that the state trial judge failed to conduct step 3 of Batson. That was the core of his presentation this morning. That defies what the trial judge said, and it once again defies what petitioner has said. Years ago, petitioner agreed that the trial judge conducted step 3. On direct appeal, he declared in his reply brief that the judge, quote, made a final ruling of non-discrimination. That is step 3. That is page 484 of the joint appendix. He then ties that in a footnote to the same pages we cite here for that finding. As I said when I began, this case is extraordinary. Petitioner has conceded all that is central to his claim. Never has this court granted relief under AEDPA when a habeas petitioner has so decisively doomed his own case. This case should not be the first. I welcome the court's questions.
But counsel is arguing that notwithstanding what the defense counsel failed to do, the judge had a more active or more robust role to play. What's your reaction to that?
No case of this court says that. No holding of this court clearly establishes that, Justice Thomas. What this court's cases say is that step 3 of Batson, the trial judge, if it reaches that stage, must make a finding on purposeful discrimination, whether the defendant has carried his burden. The judge did that here.
The counsel also argues, or at least uses Miller L. as a model. What is your reaction to what he said about Miller L. and what it requires?
I think Miller L. requires really no more than on federal habeas review, state courts cannot make factual rulings that are objectively unreasonable. That's all Miller L. decided. He didn't reach the validity of a state procedural rule. He didn't rely or cite or overrule or even touch Ford versus Georgia. Didn't reach any of those things at all.
How would petitioner here have preserved under Mississippi law would not have waived these claims under Mississippi law?
I think it would have been quite easy, Justice Thomas. I mean, he could have said for each of these challenges, it would have just been 2 or 3 sentences. Perhaps for Mr. Tillman, just 1 sentence. I mean, for Ms. Lee, who was late, he could have said, Your Honor, I mean, other jurors were late. You just refused to strike her for cause, and there's no evidence of mental problems. That should be explored. That would have preserved and unlocked the panoply of arguments that he later made about her in comparisons on appeal. He could have easily done that.
But didn't the court say it was preserved? I mean, she was obviously saying, I would like to make my record with respect to the Batson observations. So the Chief Justice points out, she says, at some point, I would like to do that. So you just articulated the kind of thing you would have expected her to say, and I'm trying to figure out when she was supposed to be, or given, when she was supposed to have that opportunity.
Sure. At page 169, at page 170, at 175, 176, she could have said that anywhere there, Your Honor.
You mean when the objections were happening?
Oh, yes, of course.
Did she have to? Could she have done it after all of those objections were lodged?
Sure. She had to do something.
But when she went to do that, when she tried to do that, she said, at some point, I'd like to do that, and the court said, you've already done it. So whose mistake is that?
He did not say you've already done that, Justice Jackson. What he said was you preserved your Batson objection.
He said, I think you've already made those and they're clear in the record. And that's after this another sentence where she adds, she doesn't just say at some point. She then says, I don't want to let the paneling of the jury go by without having those objections. And the court says, I think you already made those and they are clear in the record. For the reasons previously stated, the court finds there to be all the reasons were race neutral as the members that were struck by the district attorney's office. and so the court finds there to be no Batson violation, right? She's trying to make the objections right there, and he says you already made them and there's no Batson violation, and he makes a legal error in the course of that by saying because they're race neutral, there's no Batson violation, which of course is not the correct inquiry. I think you would acknowledge.
I think, so two responses on
So right there, she's trying, I think. I mean, she could have been more assertive. Judge Mills, so your opening was forceful. Judge Mills is a very experienced district judge. He'd been a former Mississippi Supreme Court justice. He knows what he's doing. He read the record entirely differently than you did. And he pointed to this part right here where she's trying, I think, we weren't there, we don't have an audio recording, to make the objections, and the court says you already made those, they're clear, and the court finds there to be no Batson violation. I don't know. At that point, she could have said, well, you're wrong, Judge, I get that, and Justice Alito has good points on that, but it seems pretty clear at that point.
Well, Your Honor, I mean, she preserved her objection. She didn't preserve the pretext arguments, which are different than making a prima facie case or the objection itself. Comparative juror arguments are very different in response to the state's reasons than simply making a prima facie case. And she didn't raise those.
You don't think at that moment right there she's not prepared to do that?
I mean, not at all, Your Honor. I mean, the very next page, on page 170.
He says there's no Batson violation per se. I don't know. I mean, that's where Judge Mills says perhaps she could have been more assertive. And I take that point, and that's why this is hard.
Well, I think, and this would get back to, I think, you think framed it correctly earlier, Justice Kavanaugh, where you said, look, is it objectively unreasonable? Is D2 met? And I think the ways we know that are a number of them. First of all, Ms. Steiner speaks only from page 158 to 176 of the transcript. During that time, she at least 5 times inserts arguments or objections without any prompting by the trial court. There's this talk about, are there pauses in the trial court? There are no indication of pauses in here, yet 5 separate times, in addition to all the arguments she makes, she inserts herself. I mean, that was the Batson objection. There's no indication that the judge paused, looked at her, and said, well, you make a Batson objection. She inserted that. She inserted the bench conference. I'd close the point by noting at page 176 that the judge then did allow her to state the composition of the jury, her assertions about the composition of the county, and so she had an opportunity to add more, and that's all she added was bare numbers. Then we look at the post-trial motion. Even when she had days and days, all she came up with, and this was belatedly, it was the amended motion for a new trial, belatedly comes up with one sentence that points the judge to nothing about these comparisons.
Well, that's in the course of. Go ahead.
I mean, I think you've made the point that she didn't do very well, that she could have done a lot better than she did. But that's really not the question before us. The question is whether she's waived her objection. And 3 times she's told by the court that the objection has been preserved. So you're right, General. She should have said a lot more stuff. She should have been more assertive. But the only question before us is, did she waive her objection when 3 times she's told by the court, your objection is in the record. I hear you.
And this is critical, Justice Kagan. The Mississippi Supreme Court did not hold that her objection was waived. It held that her pretext arguments were waived. It upheld
That's
the finding.
slicing the bologna very thin.
It's not, Justice
I'm
Graves in
sorry,
dissent.
General Stewart.
My apologies.
Here we are, after the prosecutor has done all his, here's my race-neutral reason, here's my race-neutral reason, and then the defense counsel says, I'm not persuaded. I need to say something about this. I still have an objection. Well, at that point, of course she's objecting to the ultimate finding.
I mean,
this is after the prosecutor has given all his race-neutral reasons, and she's still objecting. So what could she be objecting to at that point?
I agree.
She must be objecting to the fact that either the race-neutral reasons aren't credible, or they're pretextual. That's what she's objecting to. But there's no other way to read the context of this colloquy without saying that at that point she's objecting. She's saying what the prosecutor gave you wasn't enough.
I agree that she is maintaining her Batson objection, Your Honor. I don't agree about the comparative juror pretext arguments that she made no suggestion of making despite many opportunities to do.
I think you're arguing this on the merits. I think you're saying she didn't say enough to allow the court to find for her. But that's not the question before us. The question before us is whether the state Supreme Court was right when it said she waived her argument. She might not have presented a good argument, but she didn't waive her argument.
And respectfully, Justice Kagan, the Mississippi Supreme Court didn't say she waived the argument writ large. It said she waived the pretext arguments that she never presented to the trial judge. And that's critically different. Justice Graves, in dissent, my friend in his federal habeas petition, agreed that the Mississippi Supreme Court resolved the claim on the merits. It held that the Batson pretext arguments, the comparative juror arguments that she had never made to the trial judge, that's what she waived.
Well,
that's what she failed to do.
Can I just follow up on Justice Kagan's questions? After the prosecutor gives the asserted race-neutral reasons, what else could she be objecting to than that those were pretextual?
I mean, I think, I think she's saying, like, I believe that I've made my case. I mean.
No. Answer my question. After the prosecutor has given the asserted race-neutral reasons, what else could she be objecting to other than that they were pretextual?
I mean, I think are you talking about page 175, Justice Kavanaugh?
Exactly.
Okay. I think there she's just making sure that her objection is preserved in the record.
What else? That's after the asserted, just answer my question. After the prosecutor has given the asserted race-neutral reasons, and she goes back to Batson, at that point, what else could she be objecting to other than that the asserted reasons were pretextual?
I mean, I think it's the ultimate conclusion the district judge reached, or pardon me, the trial judge reached, that they were race neutral in fact, and she hadn't shown discrimination. I mean, I think that's why I think she uses the word reserve, and I think she wants to make sure. I mean, that's the 175. I'd like to reserve my.
And then that's the first sentence. The second sentence, I don't want to let the paneling go by without having those objections, and then repeat myself. I think you've already made those, says the judge, and they were race neutral. Can I ask a separate, distinct question, just one question, which is, in the course of that paragraph, the court says, and this is now a D1 question.
Yes, Your Honor.
The court says, the trial court, all the reasons were race neutral as to members that were struck by the district attorney's office, and so the court finds there to be no Batson violation. Is that a legally correct analysis of Batson?
It is, in that it means that he is finding the reasons to be race neutral in fact.
But is that the end of the Batson analysis in your view?
I mean, if he's finding them to be the actual reasons, the race neutral reasons in fact.
No,
then yes.
if they're race neutral, is that the end of the Batson analysis?
If the question is just, are they facially race neutral, then that's step 2, Your Honor.
Right, and that's not the end of the Batson analysis, correct?
Whether there's a facial justification that's race neutral is not the end of the Batson inquiry.
Thank you.
What I'm suggesting.
Thank you.
Whether in the end they are race neutral is the question, right?
That's right, Your Honor.
And as to what she was objecting to, if she wasn't tacitly raising a pretext argument, what she said on 176 is, allow us to state into the record, there is one of 12 of 14 jurors are non-white, whereas this county is approximately, what, 40%. So what she's saying is that the racial makeup of the jury that was selected was so starkly different from the racial makeup of the county that that would be sufficient to find that there were Batson violations.
Right. That's right, Your Honor. And actually, in the cert petition at page 38, the petitioner emphasized this point as being part of the Batson presentation.
Counsel, I don't know how that could be. She starts her colloquy in that section by saying, I want, at some point, the defense is going to want to reserve both its Batson objection and a straight for 10th Amendment racial discrimination. That reference, I don't think it was on the 10th Amendment. I think what she meant was the earlier objection that they spent a lot of time in voir dire on the cross, whether the jury pool was a representative body, correct? There have been two
objections there, Your Honor.
All right, so she's talking about the representation argument and the Batson argument. On the Batson argument, the court starts with that and says, you have already made it in the record, so I'm of the opinion it is in the record. She says, I don't want to let the paneling of the jury go by without having those objections and court things. I think you already made those, and they are clear in the record. For the reasons previously stated, he says, all the reasons were race neutral, blah, blah, blah. And then as to the other issue is the jury pool issue. Oh, I've already ruled, based on prior rulings from the United States Supreme Court and the state of Mississippi, that jury selection was appropriate. That the jury itself, the pool, was appropriate. And those are noted for the record. It is then when she starts talking about the jury pool as a whole, that as a whole, and not on the Batson question. So I'm not quite sure that you're fairly representing her use of that one example or their colloquy on that one example.
Let me cite you something that shows that it is a fair representation. It's page 38 of the cert petition. That's petitioner's filing, where he ties that very exchange to his preservation of his Batson claim.
But counsel, I think in fairness, Justice Kavanaugh asked you what more could she have done, or why wasn't she, responding to or trying to say that there's pretext when she was talking about the Batson question. You pointed to this 40% issue that she talks about, the 12 of 14 jurors. But as Justice Sotomayor points out, that discussion was in reference to the jury composition issue and not the Batson issue. So regardless of what was happening in the cert petition, I'm talking about what's going on in the trial record, in the discussion that they were having. It looks as though the court resolved the Batson question by not giving her a chance to make any more arguments or say anything more about it. And then he says, the court, then as to the other issues, and he moves on to composition, and that's when she starts making statements about 12 of 14 jurors are non-white. So I think we have to be clear about what's actually happening in the record and not ascribe to her representations that actually don't fit.
Can I make two quick responses to that, Justice Jackson? One is, my friend conceded this morning that that point went to her trying to get to the Batson claim itself. And also,
okay, well, that's just not what the transcript shows.
But, Your Honor, we're here on AEDPA relief, and the question is whether a reasonable fact finder could conclude this.
No, I'm not talking about the question. I'm talking about what the court said they were talking about at that moment. He resolved the Batson issue, and then he says, and then as to the other issues, and there were two issues, and the other issue was about jury composition. And that's the one that she responds to with the relevant
And respectfully,
data.
I don't agree. He conceded otherwise, Your Honor.
Okay.
And I would also add, she did it without prompting. There was no, would you like to say more? I mean, she said the more that she wanted to say, and the key thing is, even when she had that opportunity, she did not present the comparative juror arguments.
I don't think it helps to misrepresent what the record obviously shows. Let me ask you another question, because it seems as though the Mississippi Supreme Court is trying to have it both ways with respect to the significance of her arguments related to pretext. Is it your position that that her argument was so central that the failure to present it waives any obligation of the court to rule on whether the reasons that the state has given are race neutral and therefore there's no Batson violation here? Because she didn't say anything about it, or as you interpret the record, that alleviates the court of any obligation to say. That's one thing that I think the Mississippi court is saying. But on the other hand, they also say it isn't necessary for the court to give her a chance. So either it's central, in which case the court had to give her a chance, or it's not central, in which case the court had to rule on it, I think, regardless. So which is it?
I'm not sure I'm completely following the question, Justice Jackson. What I would say...
What is the significance of her argument related to pretext? Is it so necessary that without it, the court is relieved of any obligation to continue to look at the facts and to actually make a finding? Or is it not necessary, in which case it seems to me that the court needed to do that regardless of the fact that she didn't bring any argument about it.
Right. So I think if you get past step 2, the court has to make an ultimate finding on non-discrimination, but it does so in light of the parties' submissions. No precedent of this court requires the judge to consider matters, especially intricate comparative juror arguments that are not presented to it. I mean, that's something this court, it's in light of the parties' submissions.
Justice Jackson.
I just wanted to, and your view is that if the court has to do its obligation in light of the parties' evidence, the court does not have the obligation to turn to her and say, what is your evidence about this? The court doesn't have to solicit the evidence from this party or give her an opportunity to present it.
Well, it doesn't have to affirmatively do that. There's every indication that in the trial, in the record here, and a reasonable person could certainly read the record to allow multiple opportunities to present that. There's nothing supporting the idea that the trial judge cut her off, or certainly nothing compelling that view of the record, Justice Jackson.
Thank you, counsel. Justice Thomas, anything further?
Yes, General Stewart, would you were about to discuss the role of AEDPA in our review. Much of this is being discussed as though we're on de novo review. So would you discuss what AEDPA requires?
Sure, Your Honor. I think we've been very focused on the D2 piece, so I'll lead with that. But there have been various discussions about, could the record be read this way? Are there pauses that allowed her to step in? Did the trial judge actually turn to her and give her this opportunity? I heard lack of clarity. All those things mean that the petitioner can't be granted relief under D2. The record has to compel a finding that the trial judge failed on some factual matter, and it just cannot possibly compel that finding. As I've emphasized, petitioner himself took a very different view of the record, and he now says the view that he took is objectively unreasonable. And I think that goes for the legal matters too, Your Honor. There has to be something objectively unreasonable here, and the record can be read certainly either of two ways. That would be enough on clear error review, Anderson versus Bessemer City. It's certainly enough for the state under AEDPA. Thank you, Your Honor.
Justice Alito? Justice Sotomayor?
You seem to be suggesting that the only way that we could overturn the Mississippi or honor AEDPA is if the district court had said to her, sit down, counsel, you made your Batson challenge, period. Anything short of that, they couldn't err in finding a non-waiver, a waiver.
Given the entirety of this record, there's no other
Well,
reason.
no. I'm saying your argument seems to be that only if the trial court said, counsel, sit down, Batson's been preserved. I don't want to hear anymore. That's the only way that on AEDPA review we could say Mississippi made an unreasonable determination of fact.
Again, given this record, that you would
Where
need
have
something
we
like
ever
that.
said that a waiver has to be that explicit? Don't we infer it from evidence?
Well, even if that were true, Justice Sotomayor, this gets back to what I'm
Even
saying.
if it's true, AEDPA, an unreasonable doesn't mean that all interpretations of a record are correct. I'd like you to point me to one part of this record, one word by the court that says, do you have something more on race neutrality?
But that's exactly the point, Justice Sotomayor. She has none of that, and she has multiple indications that she could have.
No, the problem is that she was never given an opportunity on this record. The way the record, we can go, I'm not going to argue with you on this point.
May I respond just briefly? I think I could say something helpful on this, Justice.
No. I was going to ask one last question, okay? On the preservation issue, not on the preservation issue, on the comparative jury analysis on appeal, in answer to Justice Barrett's question, appellate courts can do their own comparative juror analysis, even if not preserved below, correct?
They can.
That's what happened in Miller, L., and Schneider. Do you believe the Mississippi Supreme Court says it cannot consider those arguments because of the waiver, or that it's choosing not to consider them?
It's saying that in general it does not. It can exercise its discretion to do so. We know that
it could do so.
it could do so.
So is that a plain error standard? Because plain error is what federal courts use to review evidence that has not been presented, an objection that has not been preserved below. It would be plain error, correct?
I mean, that's what has been said in the case. I mean, Flowers versus State 3, the Flowers case, I mean, what the court says was because the error in upholding the strike of juror Pittman affects a substantial right, we apply the plain error rule to find a Batson violation occurred.
So
I mean,
Mississippi has a similar plain error rule. It has discretion to overlook a waiver, correct?
It has discretion.
So if the record is clear that there was a Batson violation, and we can argue about each individual juror, whether the record is clear or not. I want you to make an assumption. If the record is clear that there was a Batson violation, would the Mississippi court have erred in failing to conduct that review?
And the answer is no, certainly not under AEDPA.
No, none under AEDPA. It's a constitutional violation in a case where the court below did not make an actual Step 3 analysis. You're saying that it wouldn't have been error.
I mean, that's consistent with the waiver or forfeiture of constitutional objections generally and with jury selection in particular.
We apply plain error.
But state courts don't necessarily have to do that. They can do pure discretion. They can do different approaches. Nothing in this court's cases bar that, Justice Sotomayor. And I mean, I would just emphasize that this is a rule that has been embraced by most federal courts of appeals, and it's one that was surely reasonably applied
Yes,
here.
because we apply plain error.
Some do, some don't. And again,
You always have to apply plain error.
that's not.
Plain error is required by the rules of federal procedure. If an objection has not been preserved, the court has to determine whether the error was harmless,
And I'm sorry, Justice.
whether the error was harmless.
May I respond to that one, Justice?
Yes.
I'd come back to Ford versus Georgia, where the court affirmed that state courts can adopt these timeliness rules. Perforce, those rules are going to block some claims, perhaps even some meritorious claims. And given that signal, it was surely reasonable to adopt this rule, which ultimately vindicates and enforces Batson itself and makes for better Batson rulings as we do.
Thank you, counsel.
Justice Kagan?
General, I want to take you back to the conversation that you and I were having and that you were having with Justice Kavanaugh, which is just this question of waiver, because I do believe that given the Mississippi Supreme Court decision, that's the only question before us. The question is not whether this defense counsel put enough in the record to actually prevail on a Batson claim. The question is instead whether the Mississippi Supreme Court got it really wrong when it said that she had waived her argument that there was a Batson violation. And again, I'm just staring at this transcript, and I guess as to that question, I don't really see the ambiguity in this transcript, because this is coming after the fact of the prosecutor saying we had race-neutral reasons for all of them, and she says 3 times, I want to contest that, and the court says over and over, it's in the record, it's in the record, it's clear in the record. And when a court says that to you 3 times, I actually don't believe that it's like, I'm not going to say, what can you do? I think she could have done more. I think she could have said, Judge, really, like, I'm not moving on to anything else until I get this out. But on the other hand, it's hardly ineffective assistance of counsel to make a different kind of choice, to say I don't want to antagonize this judge. If he's insisting on moving on, I better move on. That probably was a wrong decision. I'll say that that definitely was a wrong decision, but that's not the question before us. The question before us is only whether she waived her objection. And how could she possibly have waived her claim that there was a Batson violation when she says it 3 times and the court says 3 times, it's in the record, you've done it?
Okay, I appreciate that, Justice Kagan. I'd make 2 points. One is I really have to emphasize it's not a holding that she waived the objection or the claim. It's a holding that she waived the pretext arguments.
I'm saying that what they said, the pretext argument is just a way of establishing a Batson violation. So if you keep on saying there's a Batson violation here, then you're saying there's something wrong with what the state has told you about their race-neutral justifications. And if you tell me that she had to use the word pretext in what she was saying, I'll tell you That's not the standard.
And what I'm
That was
saying, Your Honor,
polite.
is that she had to give the judge a chance to rule on the comparative juror arguments that she later claimed were central to her argument. She did none of that. She didn't give the judge a chance to rule.
Okay, and in terms of giving people a chance, the judge is the judge. The judge has every chance in the world to rule on whatever she wants to do. The judge could have said, okay, I'll put you to it. Show me what you got. So you don't have to give the judge a chance.
Well, I mean, Judge, Justice Kagan,
And the judge said it's all in the record. It's all in the record. It's clear.
No, respectfully, he didn't say that, Justice Kagan. He agreed that the objection was in the record, and all she said was, I want to reserve the objection. And he said it's and that's what he gave her a signal to. What I'd emphasize, Justice Kagan, is,
You think that the judge thought that she was only objecting in the same way she did at the very start of the inquiry, that she was just making that's like a prima facie case? I mean, obviously, the judge did not think that. The judge thought that she thought that there was a Batson violation, and she said, and he said, enough. It's in the record.
And here's the key point, Justice Kagan. Whenever my friend or any hypothetical needs to suggest that the judge cut her off, it always has to use words that are not in the transcript. And she referred not to pretext, not to the desire to make more arguments. She didn't say, Your Honor, I didn't make some arguments that I would like to make. Can I just take a moment to preserve those? And every indication of this record is that he would have allowed her to. I mean, he allowed her to make an extended argument challenging death qualifications, even though she conceded it was doomed. I mean, she talked about carpool routes and juror medical issues and jurors being married to each other. When she wanted to say something, she did, and the judge heard her out and very often ruled for her. And this part of the transcript, just like when the actual Batson challenges in Step 2 and Step 3 were occurring, she didn't say any of that and didn't give any indication, and she still didn't do so in her post-trial motion. So that's what I'd emphasize, Your Honor.
Thank you.
Justice Gorsuch?
Briefly, I hope. Should you lose, what is the appropriate remedy? Let's say you lose on the D2, so there's an unreasonable determination of fact. I know you're going to want to fight the hypothetical, but please don't.
Very good.
This court would find there's an unreasonable determination of fact, but under 2254A, of course, we can only grant a writ if we find a violation of the Constitution. So there's obviously more work to be done after we decide the waiver issue. Can you explain how that's going to proceed?
I mean, I think, number one, there would need to be a showing of a substantive, I think, Batson violation, potentially, overcoming E1, for example, in district court. If this court or the lower courts were to think that law and justice were shown in this case to warrant issuance of the writ, I mean, I think it would go back to the state courts. I mean, this would depend. If the court finds a substantive Batson violation, I think.
Well, no, we're likely, assume we're not going to make that inquiry. We're going to confine ourselves to what we spent the last 2 hours talking about, which is the waiver issue, okay? And we find an unreasonable determination on the waiver issue. What more does a federal court need to do?
Got it. I mean, I think, as we've said in our papers, the possible remedy in that case, when it goes back down the federal chain, would be a writ that would require release if the Mississippi Supreme Court does not, in a certain amount of time, undertake whatever analysis this court holds to be lacking. So if that's do a new Step 3 analysis in light of the relevant arguments, that would be the measured remedy there. I think that'd be consistent, for example, with what's appeared when, say, habeas is granted on a question of whether a confession was voluntary. You don't necessarily need to do a retrial. You just need to see if the confession was voluntary. If it is, things can stand. I think similarly here, Justice.
Justice Kavanaugh?
A couple things. First, I agree with you that the court does not need to do anything if at the point in the transcript we've been focused on, defense counsel had said, I withdraw my Batson objection, or having heard the asserted reasons, I have nothing on pretext. So I agree with you in that situation, but that's obviously, as we've explored, not what looks like it happened here. You've said that she could have jumped in again after that colloquy on 175, after she twice raises it. But at the end of that, the district court says the court finds there to be no Batson violation. Now, again, as Justice Kagan said, could have jumped in, But at that point, he said, you've made the objections, you've preserved them, and there's no Batson violation. Right?
I agree with that framing because, again, made the objection, Your Honor. I think that's the critical thing.
And then for why, there are two possibilities for why I think it got truncated here, which we've all explored. One is that the trial judge had a misunderstanding of what Batson required, didn't understand the third step, and that's in that sentence that I read before. Well, all the reasons were race neutral as to members, and so there's no Batson violation. Right? So that's one possibility. The other possibility, and Judge Mills in the Federal Habeas District Court alludes to this, because Judge Mills applies AEDPA, correct?
He says he does.
Right.
I agree with that.
Yeah, no, but he articulates the AEDPA framework. He's a very experienced district judge. He's been on Mississippi Supreme Court justice. He says he's applying AEDPA unreasonable. And what he says happens is it stopped after two steps. Simply put, no state court, whether it be the majority in the Mississippi Supreme Court or the trial court, conducted a full three-step Batson inquiry. And then he explains what he thinks could have happened. He's generous to the trial court on this, I think. The trial court, seemingly eager to proceed to the case itself, quickly deemed the reasons as race neutral and moved on. The trial court's actions, perhaps understandable and relatable to this court, speaking to Judge Mills, trying to show empathy, I think, for the burdens on a trial judge, are error nonetheless. So I think, whether the trial judge misunderstood the third step or the trial judge was just, rushing it along to try to keep things moving or whatever, it just never happened. And that's Judge Mills, again, applying AEDPA, or at least articulating AEDPA. I agree with Justice Thomas completely. We have to look through the AEDPA standards here.
And so I appreciate that, Justice Kavanaugh. To take the second bit first, I would come back to petitioner's own words where he declared on direct appeal that the trial judge did decide step 3. And this is surely a fair reading of that record. That's page 484 of the transcript. And he, again, links that to the same parts of the transcript that we do in footnote 4 on page 484. And I think that's quite important. I think it shows that it's not objectively unreasonable to find that the trial judge did conduct step 3 here. Could it have used better, more clear words? I think, of course that's true. But what I think the judge was really doing was he wanted to be clear. I am finding these race neutral in fact. I think that is what he was doing. That is surely a permissible view of the transcript. And therefore, on clear error and certainly on AEDPA review, I think it is the compelled view in this case.
Last question. Sorry to prolong it. Obviously focused on this. But the reason this matters is this is a death penalty case, right? And he was 17 when he committed the crime, and he did not that this is good, but he was not the shooter, correct?
That's right, Your Honor. I mean, not the fatal shooter. That's right.
Thank you.
Justice Barrett?
General Stewart, I just want to understand your answer to Justice Gorsuch on remedy. So if we think that the Mississippi Supreme Court was wrong on the forfeiture/waiver point, I don't understand how it gets back. You said something about it you said this in your brief, something about it getting back to the Mississippi courts. Wouldn't the remedy be that we send it back down below for then the federal courts to analyze whether there was a Batson violation based on the comparative juror evidence? I just don't see the route of bouncing back. It's not direct review.
Well, I guess so it would not be, we didn't suggest remand to state court straight from this court, certainly, Your Honor. I think we're responding to the suggestion that the writ should issue here at all. I mean, my friend has maintained that the writ should flat out issue ordering release or retrial. And our view is that if a federal district court is issuing the writ here, the most it can do is an order that would correct the actual violation, which by hypothesis here is not conducting a full step 3 analysis. And that could be something that is resolved by the state courts and would eliminate the constitutional.
So you're saying the district court shouldn't, if we sent it back down, I agree, we did not grant cert on the Batson question, so that's not for us to decide. But if we sent it back down, you don't think that the district court, or frankly, the Fifth Circuit, I mean, he said that the court has what it needs in the record to look at the comparative juror analysis. Why couldn't the federal courts make the Batson determination themselves?
I think that would also be an option. I mean, I think if you sent it back down to the Fifth Circuit and said, hey, look, you were wrong to find waiver, I mean, I think it would have everything it needs in the Fifth Circuit to just flat out rule on the Batson violation. As we said, you obviously know the merits of our position, Your Honor, on that one.
Of course. Okay, thank you.
Thank you, Your Honor.
Justice Jackson, anything? Thank you, counsel.
Thank you, Your Honor.
There we go. Rebuttal? Do we allow rebuttal here? Or is it
Ms.
waived?
Ferguson?
Mr. Chief Justice, and may it please the Court, state and federal appellate courts routinely decline to consider claims, issues, and arguments that were not preserved in the trial court, consistent with historical tradition. The Batson context is a particularly important time to apply
one of
that
the
rule.
amici.
Whether a Batson violation has occurred is fundamentally a question of fact. Requiring parties to preserve their arguments that a prosecutor's stated reason is pretextual ensures that trial courts can consider all of the relevant information as they make the factual determination whether discrimination has occurred. And it allows prosecutors to explain their strikes and decisions not to strike when the reasons are top of mind. Justice is better served when these questions are aired before the jury is sworn, when any errors can be fixed, rather than through a cold record on appeal. The Mississippi Supreme Court did not unreasonably apply federal law or unreasonably determine the facts when it determined that petitioner failed to preserve his Batson pretext arguments in the trial court. This court should affirm. I welcome the court's questions.
Well, Ms. Ferguson, would petitioner have preserved this argument, the Batson arguments, if he had been in federal court?
No, petitioner would not have, I think, preserved the arguments. The federal courts would apply plain error and consider those arguments under that standard.
What do you do with the points we've been talking about on page 175, where the defense seems to be looking down the road for something that's going to happen, said at some point, I'm going to want to reserve these questions. And the judge does say, you know, you've already made those, they're clear on the record. In other words, his response, the judge's response to I'd like to reserve them is that you have.
Well, Mr. Chief Justice, I think that that was likely a demonstration by defense counsel that she wanted to say more, and she in fact did say more. And so that I'd like to respond to something that was of significant discussion during the state's argument, which is that reference on JA 176 to the statistics. And the fair cross-section requirement applies to the veneer, not to the selected jury. So when the defense counsel is referring to the number of black jurors who are on the selected jury, not on the veneer, that necessarily is an argument in support of the Batson claim and shouldn't be an argument in support of the fair cross-section claim because she's talking about the selected jury. And so I think the suggestion that that was only about the fair cross-section claim and not about the Batson claim just doesn't make a ton of sense. And I think it shows that she was in fact given the opportunity to raise additional Batson arguments, and she chose not to raise any argument as to jurors.
You're saying when she said at some point I'm going to want to reserve this, that was the half page of the record later?
I do think that that's when she took the opportunity. And she could have said, you know, if I may, Your Honor, I have additional arguments to make. She didn't do that either before she said I'm going to want to make or after she said I'm going to want to make.
In the federal courts, they already have plain error review, and counsel for the state tells us that the state also has the discretion to consider a plain error, correct?
That's right, Your Honor.
All right. So if the juror comparison is clear from the record that there was a Batson error, that could be reviewed and should be reviewed by the Mississippi court, no?
Well, I think 2 points on that. One is, you know, just the existence of an error being plain is not sufficient to make mandatory plain error review. And so under state law, the state court had discretion to consider that argument or not, depending on the other prongs.
If a step 3 analysis was never done by the court, how could it not be an abuse of discretion to fail to have done it by someone? It's a judicial obligation to do a step 3.
It is a judicial obligation for the court to engage in step 3, but I don't think it's an accurate depiction of the record to say that the trial court here did not make a step 3.
I know we're going back and forth on that point.
And I'd add one more response on that.
Oh, go ahead.
I'd add one more response on that as to the existence of a step 3 finding here, and that's in this court's decision in Perquette. The court said that the state court had found at step 3 that the prosecutor was not motivated by discriminatory intent. And the way the court describes the facts in that case is that the state trial court, without explanation, overruled respondent's objection and impaneled the jury. So I think that's very similar to what happened here. And the court found that there was, in fact, a step 3 finding, even though there was no explicit, I find the prosecutor's stated reasons to be credible.
How could there be a step 3 finding if usually that's evaluating whether the race-neutral reason is the true reason or whether instead it was pretext? If there has been no argument that it's been pretext, how could there be a step 3 analysis? That's point 1. And then point 2, Judge Mills, who evaluated this, the federal habeas court, flat out said multiple times it ended at step 2.
Well, Your Honor, I don't think that Judge Mills was right to say that it ended at step 2. And I know you pointed out earlier the state court's line that all the reasons were race neutral. I think that saying all the reasons were race neutral, to Justice Alito's point, demonstrates that the trial court, at least implicitly, had found those to be the actual reasons. You don't have a situation where the trial court said the prosecutor stated race neutral reasons, and so we find there to be no Batson violation. That would look like a state court that was misunderstanding what Batson requires at step 3. If the state court said that only stating race neutral reasons was sufficient. But here you had the state court say all of the reasons were race neutral. And I think that's enough, particularly given what this court found in Perquette, to show that there was an implicit credibility finding there.
What about the court saying all of the reasons were race neutral, and so the court finds that there to be no Batson violation?
Justice Jackson, I think the answer is the same, and that's because, again, if the reasons are race neutral, that implies that those are the actual reasons, and that's distinct from saying the prosecutor has stated.
But isn't that collapsing 2 and 3? I mean, 2 is race neutral reasons, 3 is are they pretextual, and we've said you aren't supposed to collapse those 2. So your argument just did so by saying if you have 2, then you've satisfied 3.
Justice Jackson, no, I don't think that that's our.
You didn't just say that if they're race neutral, then that means they are the real reasons?
I think if the actual reasons are race neutral, so not whether the stated reasons are race neutral. If the prosecutor has merely stated race neutral reasons and the trial court doesn't credit those reasons, or if there's any reason to believe that those are not the real reasons that the prosecutor exercised the strikes, then you could have.
There's also a more complex way of looking at this Miller L. brings up, which is not reason by reason, but sort of the comparison, right? There's no indication here that this court did any sort of comparative work, which would have been what we would have expected from the from the defense counsel if given an opportunity, correct?
I think certainly given what defense argued on appeal, you would have expected that.
Right. So if the comparison is also a part of the determination of pretext, how does this record indicate that the court did any of that kind of analysis?
Well, I don't think that there's any particular indication that the court was sua sponte considering arguments that weren't raised. But I think that when it comes down to the ultimate question, this court has explained several times, the ultimate question is whether the prosecutor or the striking party was engaged in intentional discrimination. And necessarily, if the judge finds that the reasons were race neutral, then race neutral reasons, in fact, being exercised is incompatible with a finding of intentional discrimination.
Can I ask you a broader question, and then I'm done? The United States has entered this case as an amicus curiae, meaning that you did not have to be here. And as Justice Kavanaugh pointed out, this case is a capital case involving the conviction of a defendant who was not the shooter, a felony murder scenario. And so I guess I'm trying to understand the United States' interest. Your brief doesn't really pay a lot of attention or devote a lot of time to defending the actual conviction. So what is the principle that you are seeking to have upheld in this case, in which it's clear that the defense counsel said several times, I have a Batson objection, and tried to preserve it in the court, if anything, misled her into believing that she had preserved it by saying it's in the record? Why is the United States interested in being involved in this case?
Well, Your Honor, the United States is a party in many trials, including many criminal trials, is subjected to Batson objections and defends in Batson cases. And so I think our interest is in defending the right of courts of appeals to exercise their discretion to consider juror comparison arguments and not, as I think petitioner, if I may, Your Honor,
Sure.
Not as petitioner argued in petitioner's brief, although it seemed to walk away from today, adopt a rule that appellate courts must consider juror comparison arguments when they are raised for the first time on appeal.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Kagan?
Ms. Ferguson, I want to go back to what you were saying before, and I'll grant you something. I'm going to assume your view that the judge here did not collapse Stage 2 and Stage 3, and the judge understood what he was doing, and that the judge made a determination that there was no Batson violation, the determination that you would make at the end of the day. Right? And in exchange for my assuming your view on that, I need you to assume my view on something else, which is that the defense counsel understood that that's the stage that they were in. In other words, that now they were talking about the ultimate Batson violation, and what she was objecting to was the finding of the ultimate Batson violation. So let's say that they were both on the same page. We understand that we're contesting the ultimate Batson violation. So if you assume those two things, and the court says there was no violation, and the defense counsel says, I object to that, I think there was a Batson violation, and he said, I got that, I understand that, it's preserved. And she says, I want to make an argument about this. And he says, it's preserved, it's preserved. How could it not be preserved?
Well, Your Honor, I agree with the state that there's a distinction between preserving a claim and preserving particular arguments, and simply saying I disagree with the ultimate finding is not sufficient to preserve every possible pretext argument under the sun. And so I think there needed to be some form of even gesturing at juror comparisons. There was nothing in the record at all until after trial to suggest that petitioner's counsel thought that there was a problem with white jurors not being struck who shared characteristics with the black jurors who were struck.
So you think in the face of the court saying again and again, it's in the record, I got it, it's preserved, she has to make clear what the particulars of her view is, why exactly there is a Batson violation?
In order to preserve those particular pretext arguments for appeal, yes, under Mississippi law.
Thank you.
Justice Gorsuch?
In fact, a lot of courts have issue preservation rules with respect to arguments, not just claims or issues.
That's correct, Your Honor.
And we've never held those impermissible before.
No, Your Honor, and in fact, this court has repeatedly reaffirmed, both in the context of Batson claims in state courts, in Batson and in Ford versus Georgia, the court has reaffirmed that procedural rules are permissible. And then in Singleton versus Wolf, this court affirmed that courts of appeals in the federal system have discretion over when to accept unpreserved arguments on appeal.
Justice Kavanaugh? Justice Barrett?
Just one question, Ms. Ferguson. Is it unusual for the United States to appear as an amicus when we have a constitutional question before us that affects the United States in litigation?
No, Your Honor, it's quite common for us to appear.
Thank you.
Justice Jackson? Thank you, counsel. Rebuttal, Mr. Perkovich?
Before the rebuttal here, I don't know, like the idea of not preserving a particular argument, to me, that seems like the difference between objection, Rule 403 or objection to hearsay. A Batson objection is a type of argument. It's a type of objection. It already has a confined context. Like, there is a particular type of argument being made just by the act of raising a Batson challenge. A Batson challenge is particularized. I want clarification on the prosecution's reason for striking a juror, using a peremptory strike, because I want to know if there was an intent to discriminate or not. Like, to me, that's particularized. That's not just objection, whatever you want it to be. So anyway.
Just a few quick points. First, I want to address the issue with may not in the Woodward case that constrained on direct review the inquiry. And that's simply the point. At that gateway issue, there was an understanding that they clearly may, and this court has done so routinely. So that's our fundamental point on that. With respect to the procedural rules that Ford versus Georgia endorse as a basic principle, we have no qualm with that. That is a timely objection rule. Of course, that's not applicable here. And with respect to a waiver rule and forfeiture, however it's framed, the problem is that it's not implementing Batson in step 3. It's obstructing Batson in step 3. And that's the work that's occurring in this case and the problem with that rule. With respect to the conflation of race-neutral findings and step 3, there is a very big step between determining something's race-neutral and determining it is credible. And that's where the work of the court, at a minimum, the trial judge, is required. Whatever is being pressed by the opponent of the strike for the reasons I pointed to and are spoken to forcefully in Powers with regard to the other stakeholders and the broader stakes for our society with regard to the Equal Protection Clause in this context. With regard to remedy, Batson, of course, ushered in a prohibition of the discriminatory use of strikes in a way that improved upon Swain and provided a specific framework. And so when that framework breaks down, as it did here, that's a structural error. And so this has to return to its prior posture, in much the way the last time this court found a D2 violation in Miller L., which is to the district court and for a judgment entered for the petitioner.
Thank you, counsel. The case is submitted.
Alrighty. So there we, oh no, Don't want to watch Brent Booth right now. My autoplay went into the Zach Adams post-conviction hearings here, which we are still waiting on a decision from Judge Brent Bradbury. A lot of us did the math, and we think the due date was this past Monday, but we're still waiting. I haven't seen any news that a decision has been filed yet. Of course, when it is, you guys will be the first people I run and tell. But yeah, so I've seen a little bit of coverage. You know, this SCOTUS argument didn't have the type of like curiosity and fanfare surrounding it as the birthright arguments today had. And I think it's an important issue. And the limited coverage that I did see about this case framed it more as a, hey, were these jurors stricken on a basis of race? And what SCOTUS is really asking, the question that they granted cert for, is a different question. As you guys know now, after watching all of that, it's really about whether or not it was unreasonable for the state Supreme Court, Mississippi Supreme Court, to find that counsel at trial had waived their Batson challenge by not continuing to argue. I think that's a very interesting question. And honestly, I feel like there's actually a pathway here where in this particular case, the SCOTUS could rule very narrowly that in this case, the judge should have allowed, rather than stating that they preserved the record. And maybe that could be used, though it would overturn, it would reverse the Mississippi Supreme Court state decision. And that would be beneficial for Pitchford. It could be constraining in the future, and maybe that type of holding could be used in the future to say, all right, well, the opportunity is there. And if we cite back to the decision in Pitchford, if you didn't take advantage of that opportunity now that they said to give it and the judge allowed you to lay out the particulars and you didn't do it, now we have better clarity to say that that was waived. So I don't know. But to me, it doesn't seem like the judge's I think enough judges seem to be asking questions in a way that show they really don't think it's a reasonable proposition to find that an issue was waived when the court tells you 3 times your objection's preserved. So that wraps up these arguments, you guys. I don't know what's next on the docket. I'd like to say it's going to be a Zach Adams decision. Tomorrow, I'll be joining, I don't know if I'm going to be mature enough to handle this, but I'm going to be joining with Miss Janet Demeanor over on her channel, and Lauren Conlon, who writes for LA Magazine and a ton of other places. Lauren is doing a ton of great coverage on cases like Luigi Mangione, things where she's boots on the ground doing the reporting. And we're going to do a panel together on the cornhole champion player that was recently arrested for shooting his friend while they were in a Tesla together. The amputee, the quadriplegic amputee. So we're going to be talking about that tomorrow. We'll see if I can keep it together and be serious. Is that later? Either way, I'll make myself available for it. Let me see. You might be right, because it is Wednesday. Thank you, Trakeisha, for being my reminder on, let's see. No, I think it's tomorrow, because she said, I put it on my calendar for Thursday. Let me double check, and I'll get you the link to her channel anyway. That way, if you guys want to hear us talk about that case. I was dying laughing this week because Lauren Conlon went and got, like, the arrest, the warrant, the affidavit, all that stuff. She's always getting the documents. And in her caption, when she shared those documents, she took the time to specify, she typed it out, according to the warrant, or the arrest, whatever, the intake form. He measures in at like 3 feet 5 inches. I was dying. I'm like, Lauren, why did you take the time to specify that detail? Oh man. So that's a little bit of the vibe to expect tomorrow. Let's see. Miss Janet Demeanor. Here is her channel link. And okay, she already has the post up for tomorrow. So that is going to be April 2nd at 7 p.m. Eastern, 6 p.m. Central Time. Come join us. We'll talk about the information behind the case. I mean, Lauren always has a really good scoop on anything she looks at. So it'll be a deep dive on the info, but I think it'll also be a fun, casual conversation, if you will. Yes, that's you heard it exactly right. Generic ad, amputee shooting in a Tesla. So, yeah, you know. Oh yes, and Cuffboy's channel. Let me get that too. I was a bit surprised and very happy to see that was a story choice that he covered. And then in that video, he did say that he was classmates with the guy. So let's see, Cam's video, Cuff Boys, drop that in the chat as well. And I'll add it to the Creator Friends playlist that I have in the description there for anyone that's watching this on replay and wants to go find these amazing things to go watch. But yeah, that's all I've got for today. Still got to find time to talk about the ongoing Fat Joe, Tyrone Blackburn, Terrence Dixon saga. Yeah, I think that's the next thing I've got on my chopping block now that the Courtney Clenny trial has been delayed until August. So with that being said, thanks for tuning in. I think hearing this issue, I mean, it's important. It's a capital case. And in addition to the context we talked about at the beginning of this stream, if you saw in the chat, Adventure Aaron had asked, like, wait, well, who was the judge for Terry Pitchford's case? And I was like, Joseph Loper, Judge Joseph Loper, whatever. And Aaron immediately realized, like, oh, that was also the same judge that presided over the Curtis Flowers case that SCOTUS overturned. So the Curtis Flowers case that was overturned because of racially based striking of jurors in 2019 by SCOTUS had the same prosecutor and same trial judge as Terry Pitchford's case. And again, this question of a waiver is really going to the heart of, should there be oversight over a judge's decision on the prosecutor's credibility and is, hey, your record's preserved, is that a waiver? And then there's no further, appellate courts can't review the judge's findings. And when you take it into this context where, well, this judge found the prosecutor credible, and this same duo had problems with this exact same issue, race-based jury selection, I think it's a very, very big deal. I don't think it's as simple as, no, but it'd be anti-waiver, don't allow that, please. So, Martina Nem says, I need to deep dive on Curtis Flowers. Adventure Aaron did recommend a podcast with the name of In the Dark? In the Dark. Yep. So search In the Dark podcast, Curtis Flowers, and that's something Adventure Aaron recommended as like the place to go for a deep dive on like 6 trials overturned in one way or another, or mistrials, combination of the two. Just crazy. I mean, if you want to put a number on reasonable doubt, I think having to try someone that many times might point to some reasonable doubt issues there. But what do I know? Also, Sheriff Chuck rounding out the stream here. He started us off with 5, gifting another 5 here. Thank you so much as always, Sheriff Chuck. Always turning the chat green, supporting what we do. And he's really probably the biggest reason that I can hopefully do this full time in the very near future. So major love for Sheriff Chuck here. And you guys have a good one. See you next time I see you, hopefully tomorrow, for our very fun panel show over at Misdemeanors. Bye, guys.